Yes.
Yes, my lord, thank you.
Yeah.
Yes, it please the court, my lord. Morning again, Brigadier.
Morning, good morning, Advocate Minister.
Remember, we were still busy with Exhibit JJ. Exhibit J, I'm sorry.
Yes.
Exhibit J.
Yes, I remember, my lord. Warrant of sustained comes statement.
Yes.
Yes, I remember, my lord.
Yeah. Now, she had an interview already with the first witness, who was Kumalo. Then the second witness that she interacted with was Zandi Kumalo.
Yes, my lord.
Yes.
First speed akhuluma naye kwakusandi Kumalo tiye.
Now she says Zandi Kumalo, this is what she says in page 4 of her affidavit. The second witness was Kelly's sister, Zandile Kumalo. She told a similar version and gave a similar profile and facial description of suspect A. The only feature she adds was the eyebrows. She saw the eyebrows when suspect A lost his headgear during the scuffling with the deceased. She could not describe the second suspect.
Uthi guy mechaza lapha uthi wachaza into efanayo wasenika incazelo echaza ngobuso bakhe kamsolo uA and into ke athi yahluka lapho ayinezezela lapha amashiya uthi wabona ukuthi ususpect umsolo uA wasuka lento ayigqokile ekhanda ngesikhathi bepushana nomufi.
Oh, sorry. No, got it. Yes, I see that, my lord.
Exactly.
Now she continues to say, the third person that I interviewed was Tumelo Madala, who was much traumatized. He saw the scuffling between suspect A and the deceased. After hearing the gunshots, he ran off to one of the rooms. He gave a similar description of suspect A. I showed him Kelly and the sister's compilation and was satisfied with the ID kit. He could not compile the second suspect. The fourth witness was Mr. L.S. Twale. I surmise here that this should have been Mr. Longe Twala. Nonetheless, Miss Steenekam says, he gave me a similar description of what happened at the scene. He saw the scuffling between suspect A and deceased. After hearing the shots, he ran out to look for help.
uthi wabona ukudonsana nosunduzana phakathi kwa-suspect A nomufi emva kokuzwa kuqhuma isibhamu wabaleka eyofuna usizo.
He could not describe the second suspect.
Akazange akwazi ukusichazela ukuthi wayenjani umsolwa wesibili.
Now she goes on to interview the fifth witness, who's Tima Kaleni.
Waseqhubeka ke nokukhuluma nofakazi wesihlanu uMr. Tima Kaleni.
But we know that Mr. Tima Kaleni was not one of the witnesses who was in the house.
Siyazi ukuthi uTima Kaleni akuye nomunye wofakazi ababesendlini.
And then she goes on to talk about the sixth witness, that is called Piwe.
Yaqhubeka ukukhuluma nofakazi wesithupha okuwuSiphiwe.
I will not waste the court's time because there's no name that is mentioned to be one of the witnesses who was in the house.
Futhi angeke ngidlale isikhathi senkantolo ngoba akuyena omunye ofakazi ukuthiwa bekhona endlini.
Then the last paragraph on page 5.
Manje ke paragraph egcina lapha ekhasini lesihlanu
says, Lieutenant, oh no, it's C.O.L. Streichner, or it's Colonel Streicher, and I left for Fosloris Detective to see Mrs. Kumalo at her house.
Mina no Colonel Streicher sasuka eFosloris detective siyobona uMrs. Kumalo endlini yakhe.
Now I surmise that this Mrs. Kumalo should be Kelly's mother. That's Kumalo, the one that we're referring here at court as Kumalo.
Manje lana ngicabanga ukuthi uMrs. Kumalo lo khulunywa ngolo esithi uMakumalo okuwumama kaKelly.
I interviewed Mrs. Kumalo at the neighbor's house.
Ndingakhuluma noMakumalo endlini ke kamakhelwane.
She gave a similar description of suspect A.
Naye ke wachaza umsolwa u-A ngendlela efanayo.
I showed her the compilation and she saw a likeness in the face.
Ngabona ke mkhombisa ke umdwebo wathi wabona ngathi kukhona ukufanana la ebusweni.
She could not describe the other suspects.
Akakwazanga ukusisiza ngokuchaza ukuthi wayenjani labanye ofakazi.
Now yesterday, Brigadier, when I put it to you that, did you in your investigation find a witness who was in the house who describes the first suspect, that is the gun-toting suspect, in a different way from which the witnesses who were in the house are describing him? You said yes, you can go and look at, if you afford an opportunity, you can go and look in one of the statements. Was quite sure that such a description is there. This is the opportunity. Did you find anything which is not similar to what Mrs. Stianekam says, and to what the witnesses who were in the house are saying?
Manje kukhona yini owalethe incazelo yalo muntu owangena lapha ephethe isibhamu kodwa ehlukile kulaba abamchazayo lo muntu ngisho laba babesendlini.
Yes, my lord. So let's start here, my lord. I understood the question yesterday, or how Advocate Nisi asked me. It was the description insofar as suspect A, in terms of the dark color, the complexion. That's where the contention was. He referred specifically in terms of the dark color. And I've said in my recollection, one will have to go through all the statements. Now, having gone through the statements, my lord, the only people that I was able to pick up who refers to the dark complexion, it's Longwe, I think Zandi, I'll just have to check, my lord. But it's not all the witnesses who were inside the house. The other, I think it's about 3 of them that give the complexion of a dark person, in other words, the first intruder being dark, referring to the complexion. The others are simply giving description in terms of the dreadlocks and the height, and then that goes to the same, that becomes the same situation when they describe accused number 2. But not all of them are saying the person is dark. And when I'm saying all of them, my lord, I'm referring to their statements. That is why I said, as much as Warrant Officer Steenkamp prepared the statement in preparation of the identikit, if you read what is contained in her summary in relation to what the people inside the house are saying, I've said it yesterday that there's no consistencies, because Kelly Kumalo, for example, the first person she interviewed, refers to a dark person, refers to a revolver. You don't find it in a statement. If you go to other places where Zandi said she could not identify certain people, if you go, like Ms. Zandi Kumalo, the second witness, if you go to Zandi's statement, she says, I will be able to identify the intruders if I see them again. So you need to read this, my lord, with what actually the deponents have actually disposed. So yes, I was able to find statements where there is no dark color or complexion being mentioned of the first intruder.
Izolo ngizwisise kahle umbuzo futhi ke lo mbuzo ubuqonde ngokule ukhuluma ngebala la lo muntu okuthiwa wangena la, kodwa ke uzofanele uma ufuna ukutholisisa kahle ufanele ufunde zonke izitatimende, ngoba ngicabanga ukuthi bathatha kuphela la ehlanganisa khona uLongwe Thwala noZandi, kodwa kubona bonke abathi lo owangena lapha wayenebala elinsundu. Abanye ke basebenzisa ke ama dreadlock nobude bomuntu and futhi abasho lutho ngebala lakhe. Kodwa uma usubheka lezi statement zalaba ke abebekhuluma ngebala elinsundu, akukho ungaguquguquki lapho kwestatement kwalento abayishoyo, ngoba abanye basho lokho abanye basho okunye. Ngoba uma sibheka lapha uKelly yebo uyakhuluma ngokuthi yebo wayemnyama lo muntu, and futhi ukhuluma nangevolovolo. uZandi yena uthi wayezokwazi ukuthi mhlawumbe mangathola ithuba akwazi ukubakhomba labantu. So kuzofanele ukuthi ubheke zonke izitatimende ukuze ngitholisise kahle ukuthi konje bathini.
My Lord, furthermore, the fifth witness that was interviewed by Ms. Warrant Officer Steenkamp, Advocate Nisi said obviously because this person was not inside the house, he didn't go into what this person says. But what is prevalent as well, and that is why you have to look, because that is how I conducted investigation. You don't look at an incident and isolate it, you investigate holistically. Tim Makaleni, my lord, gave a statement where he says he saw 3 intruders coming directly from Kumalo's house. Directly, and he says one of those intruders was carrying a firearm. The statement is in the docket. So then it becomes prudent, for him to identify, or rather to assist in the sketching of the identikit. And I think that is why he assisted in identifying the person or one of the intruders, my lord. But he places himself in a position where he says he saw intruders coming directly from Kumalo's house. He referred to that name, and one of them was armed with a firearm.
Manje uma uthi ufanele ubheke wonke amaphuzu owahlangana nawo ekuzameni ukuphenya, ufanele ubheke konke, awubheki into eyodwa, kodwa ufanele ubheke konke ohlangana nawo, ngoba siyazi ukuthi nanoma uthi Makaleni wayengekho endlini, kodwa ke washo ukuthi yena wabona abantu abathathu bevela endlini bephuma endlini, and washo ke nokuthi oyedwa wabo wayephethe isibhamu. Yikho ke kwakwazi ukuthi asize ukuthi kwenziwe loya mdwebo loya ukuthiwa identikit.
And lastly, my lord, I've considered and agreed with Advocate Nisi that not all the witnesses, where we differ, it's not to say all the witnesses describe the first intruder as dark. Where I've considered is that in terms of the description of the intruders, you have a bit of inconsistencies in terms of the description. There I concede, my lord. However, as I've said yesterday, the prominent and the main thing that you find in all the statements of the people who were inside the house is that they were intruders. The first intruder was shot. he was armed. The second one was told. There was a demand of cell phone and money. There was a struggle, and the gunshot went off, and the deceased was then shot. You know, that is consistent, my lord. It's insofar as the description, you know, finer details of the description of the accused. For example, my lord, it was also mentioned, without taking it further, that somewhere, perhaps let me not go there. I will want Advocate Minister to lead me so that we don't step on each other's toes. Let me just leave it at that for now, my lord.
Okunye-ke siyazwana nobamnisi ukuthi yebo kukhona ungahambisani kobufakazi lana khona la ukwehluka ukukhona ngoba ke nanoma nje laba abanye bechazela ukuthi umuntu wayelapha wephethe isibhamu wayemuntu unebala elimnyama kodwa ke akusho ukuthi laba abanye nabo bachaza kanjalo into ke nje abayishoyo ukuthi ke lo muntu wayemfishane wayephethe isibhamu nokuthi wafika wacela amafoni nokuthi ke emva kokuthi kudutshulwe lapho ke base beyaphuma babali ikona nje kuphela.
Yes, my lord, that's my answer.
Thank you, Brigadier. You know, I said that I would not waste the court's time by referring to what Mr. Timakaleni is saying. Now that you're mentioning Mr. Timakaleni in an endeavor to try and justify the theory that accused number 3 could have been the person that was in possession of the gun or of the firearm. This is what Makaleni is saying. According to Mrs. Steenkamp, she says, the fifth witness, Mr. T. Makaleni, residing at Mozamo 3942, compiled the suspect of B, compiled the face of suspect B. He saw 3 unknown African males in the vicinity of the gas station, busy on their cell phones. He saw them again at Kelly's mom's house. Suspect B stood at the gate. He gave the following description.
Manje kumhlola wesihlanu uthi Makaleni nje usho ke kuka Steenkamp uthi ke lana uthi lona uhlala emzamo 3942 uthi wasinika incazelo ukuthi kunjani ubuso kaMsola uB uthi wabona amadoda amathathu abantu abansundu bese duze negarage babekhuluma ke nje noma khale khukhuni wabo and uthi waphinda wababona futhi ngasendlini ka mama kaKheli umsola ke uB wayeme ngasesangweni wasenika ke nathi incazelo yakhe.
An African male, plus minus 25 years of age, plus minus 1.80 meters tall, slender build, medium brown complexion, clothing, black hooded top. Witness saw a golden insect in the upper teeth. Hairstyle, dreadlocks, facial hair. He had a mustache and a beard. He slave with beard. Thank you.
Uthi ke lapho kwabona umuntu umAfrika wesilisa eneminyaka cishe ngaba 25 wathi ke ubude bakhe 1.8 meter and futhi ke lapho kuyabonakala ukuthi wayengakhuluphele wayenje futhi ke nebala lakhe lalingakhanyi kakhulu laliphakathi nje nendawo uthi wayegqoke ihudi emnyama and uthi wabona ke ukuthi unezinyo legolide ngenhla and futhi ke inwele zakhe kokwama dreadlocks and futhi ke wayenobu kusho ukuthi wayenamadevu futhi enentshebe.
He also had facial hair.
Futhi ke uyabonakala ukuthi wane nenwele ebusweni bakhe.
Now, 1.8 meters tall. It's somebody that is just, I'm 1.8 meter, I'm 1.82 meters tall.
mina ke ngina ubude bami u1.82 wamamitha.
So, plus minus that person could have been of my height.
Tikusho ukuthi ke lo muntu wayecisha lingane nami.
But importantly, Mr. Makaleni described suspect B.
Manje kusemqoka lana ukuthi uMakaleni ukhuluma ngomsolwa uB.
Now, these are two individuals
Manje labantu la abantu ababili
that should be separated in terms of the intruders who got into the house.
abafanele bahlukaniswe njengabantu abahamba bayongena endlini.
Do you understand?
Yazisisa.
Yes, I fully understand and I agree with Advocate Mnisi, my lord. However, I think perhaps we didn't understand each other.
Okay.
So my endeavor, as Advocate Mnisi is putting it, it wasn't insofar as accused number 3, because I didn't say Makaleni identify accused 3. What I've said, I said the relevance, the endeavor that I was trying to put forward is that the assistance of Makaleni insofar as the compilation of the identikit, my lord, was necessary because in his statement, he says he saw 3 intruders coming out of Kumalo's house and one of them was identified, or rather he saw one of them carrying a firearm. I did not say that, and that's why I think there was a misunderstanding, that him assisting in the identikit was the drafting or implicating accused 3. I simply said because of that contained in his statement, it was then necessary for him to assist in the drafting of the identikit. Hence, he assisted in the compilation of the second intruder. So I was making it a point that the fact that he was not one of the people who was inside the house, although he was outside, but he was able to see the intruders running out of the house and assist in the drafting of the identikit of suspect B, the second intruder. So they were in the same page, but it was not to say I'm saying accused 3 or he assisted in the drafting of the identikit for the first suspect. I think that's where the misunderstanding was. We are on the same page.
Cha khona la besingazwani kahle no ngoba umnisi ngoba mina bengizama ukusho ukuthi ke uMakaleni ubengakhulumi ngalomuntu umsolwa wesithathu futhi ke ukuthi usizo lwakhe beluvelaphi beliphuma nje ekutheni yena uthi wababona abantu abathathu bephuma endlini nokuthi khona oyedwa owayephethe isibhamu and yikho ke wakwazi ukuthi azosiza ekutheni kwenziwe lo yamdwebo le and ngoba yena wababona abantu abangena lapha hayi ukuthi ke wayezama ukuchaza ukuthi umsolwa wesithathu wayenjani.
My lord, the court will also, just to support what I'm saying, that I'm not tip-and-toeing, is that the court will recall that when I was dealing with the very same exhibit with with Mr. Ramsipil, we dealt with this and I indicated that the correlation insofar as accused 2 is concerned, or collaboration, is that at that time in 2014 he was 25 years old. I was specific on this, the court will recall and the record will speak for itself, and I mentioned the issue of the black hoodie, which was then corroborated by Zungu, Constable Zungu, when he gave a statement that he saw accused 2 at a hostel at some stage wearing a black hoodie. So I'm saying this assertion by Makaleng was very clear that it relates to a suspect 2, not necessarily the first suspect.
Manje ikata lizokhumbula ukuthi ngesikhathi sikhuluma no Baba Ramsipili kwasilana sasikhuluma ngomsolwa wesibili ukuthi umsolwa ngaleso sikhathi wayeneminyaka 25 and futhi ke uZungu iphoyisa la kwazi ukuthi kumbone lapha ehostel labona ukuthi wayenehoodie le emnyama ngoba uthi yena wambona hostel.
Yes, that's my answer.
Thank you, Brigadier. My lord, yesterday I dealt with some correspondence or certain letters that came from the Legal Practice Council. I was missing their exhibit numbers. Those letters that are referred to are in paragraph 154 of the list of exhibits The first letter is Exhibit Y, and the second letter was Exhibit Y2. I think they relate to the confirmation of the enrollment of Advocate Mchiyako as an advocate with the LPC. But importantly, those were the exhibit numbers that I tend to refer to. There was also a charge sheet that contained another letter from Rustenburg that I also referred to. Thank you, Madam. Thank you, Brigadier. Now,
Yes.
I again do not want to labor this point, Brigadier, but let me put it to you that in terms of the description of the person who had a gun when they got into the house of the Kumalos, the description by the occupants of the house of that intruder consistent. A dark-skinned person who had dreadlocks. That is the common denominator, if I were to borrow from your parlance. That is a common denominator. It's a golden thread that runs throughout their description of this suspect. A dark-skinned person who had dreadlocks. As I'm saying, that is what I'm putting it to you.
Manje malana ncazelo yalomuntu oyiphethe isibhamu lethwa yilaba ababesendlini ukuthi ke wayenebala elinsundu futhi wayenama dreadlocks and futhi ke lokho akuguquguquki bonke bakubeka kanjalo.
No, my lord, I disagree. Not all of them, and we can go through to the description. That's why I said I could pick up 3 of the people who were inside the house who relates to the dark skin, in terms of the first intruder. Not all of them. So it's not a general remark. That's why I indicated what is common in all the people that were in the house. Insofar as the intruders demanding cell phone and money, I've indicated those things. But insofar as the description, some of the witnesses that are that were inside the house at the time are describing the first intruder as dark, but the others are not giving the complexion of him as dark, my lord. And the statements are here to confirm that.
Futhi ke angivumelani naloko ukuthi bonke basho njalo ngoba abathathu kuphela ababekhuluma ngebala elinsundu. So okusho ukuthi ke akuyona into efana nayo kubo bonke le eshoyo into engathi ingafanana ile ndaba ye cellphone nokuthi bafuna imali ngoba abanye abazange balikhiphe nebala labantu.
Were the similarities, my lord, or rather where an impression is created as if everyone in the house are saying the first intruder was dark, it is contained in Exhibit J that Advocate Mnisi was taking me. This is now Warrant Officer Steenkamp's statement, because he says they are almost like conquering each other. But if you go to the statements, because these witnesses or the people who are inside the house dispose affidavits, my lord, they are not saying that, my lord.
Futhi ke into kenza ukuthi kubukeke sengathi bakhuluma into eyodwa yilento etholakala lapha ngisho laba ababesendlini ilento etholakala lapha ku exhibition J nelincazelo isithole lapha ku Warrant Officer Steenkamp. Kodwa ke uma siya estatementini siyubona lo mehluko ukuthi umehluko ukhona kulabo ababekusho.
As a court, please, without interfering with Advocate Mnisi's cross-examination, he's referring to Exhibit J, and if one looks at the description given by Ms. Kelly Kumalo, the report mentions in the middle of the report, African male in his mid-20s, dark brown, shiny complexion. Now, the word Brown has been omitted in putting the proposition to Brigadier Gininda. It's important to keep that description in mind. Dark brown, shiny complexion.
Is it please the court, my lord? Now, Brigadier. You constantly, let me just write this down. Now, you constantly has been mentioning throughout your testimony that Kelly Kumalo is the mastermind behind the death of the deceased, Senzo Meyiwa, not so?
Kaningi emfakazini bakho uveza ukuthi uKelly Kumalo uyena ophambili kulesahlakalo sokubulawa kamufi uSenzo Meyiwa.
Yes, my lord, based on the investigation, not my assumption. I mean, I think I made references to where her name comes from, you know, and that starts from accused one going up to, you know, and then obviously then the investigation that we conducted. So, but it starts from there, my lord, going up.
Yeah, but lokhu kuvela kuphenyo esalwenza akukona nje okuphuma engqondweni yami engizicabangela kona kodwa kuvela kuphenyo esalwenza yebo na kuloko kwalethwa umsolo wokuqala.
Thank you. Is this a narrative that is also shared, or that was also shared by the prosecutors who assisted you in this investigation?
Manje shothi lokhu umbono walethwa futhi nayilaba shushisi ababenisiza kuphenyo lweni.
I don't see the relevance of this question. There was a decision to prosecute the current accused before this court. As to what view the prosecuting team held is irrelevant. So we have to focus on the accused that are before this court.
Is it please the court, my colleague should not be understanding me as not been concentrating on this case. The witness, my lord, has testified many a times that there were certain things that it did not do because it did not have specific instructions from the team of prosecutors who were assisting him in investigating this case. Consistently maintained that Kelly Kumalo is the kingpin in the assassination of the deceased in this case. I don't know, therefore, on what basis it is then alleged that the question that I'm asking him as to whether or not the team of prosecutors who assisted him shared the same view that Kelly Kumalo was a kingpin in this case. I don't know on what would then be the irrelevance of that question, my lord. Thank you, my lord. Did the team of prosecutors who assisted you in this case also share the same view? Were they part of that narrative that Kelly Kumalo is the kingpin?
Nje-ke laba-ke ababekusiza ekuphenyeni nabo babe nawo lo mqondo yini ukuthi uKelly Kumalo uyena wayephambili kulokho.
So my lord, I wouldn't say there was a narrative from the prosecutors. Evidence that was collected, my lord, at some stages I indicated was presented to the DPP, and further instructions insofar as Ms. Kelly Kumalo were given, up to the point where we read the statement that I made in November, my lord, and I indicated that there was no decision taken at that stage, to bless the arrest of Ms. Kelly Kumalo. So there wasn't an objection. It was a question of further instructions and the adoption that the NPA was taking at the time, my lord.
Engingakusho ukuthi ke lokhu kwavela kubufaka kubuphenyi esasibenza and futhi ke sakudlulisela ku DPP kodwa ke njengoba bese ngichazile ukuthi kwakungena sasingekho isinqubo sokuthi ngaleso sikhathi akaboshwe uKelly Kumalo.
That's my answer, my lord.
I did not get really what my answer to the question, to my question is, because the question is very clear. Was the team of prosecutors, or was it part of their narrative, their viewpoint that Kelly was the kingpin in the assassination of the deceased in this case? Irrespective of whether Kelly Kumalo was charged or not, did they hold that view in terms of your discussion? Remember, your discussion is not privileged. It's just not privileged, which is the reason why you had to come and tell this court that they gave me these instructions, they did not give me those instructions, I did this because of what they told me, they guided me here and there and there and there and there and there. Do you understand? Now,
I understand.
the question is, were they part, was it their narrative as well that Kelly was a kingpin? Thank you.
The witnesses answered that question. Must he repeat his answer? If so, what is the reason why he should repeat the answer that he's already given, my lord?
Maybe I did not get your answer, Brigadier, and there is nothing wrong in me requesting you to repeat your answer. There's definitely nothing wrong in requesting a witness to kindly repeat your answer.
Angizange ngiyizwe impendulo yakho sengicela ukuthi ngicela ungiphindele impendulo yakho.
My lord, the essence of my response was that there was no decision taken. Insofar as the sharing of the narrative, my understanding, and this is how I've been dealing with the NPA from time memorial, you conduct investigation as a police officer, you present the evidence to them. They decide as to whether to enroll the matter or not. And then if there is a need for further investigation, such will be communicated. And I've testified about this, my lord. So I'm not so sure if I can take it further than this insofar as what the advocates, because I can't get into their minds. What I know is what I presented to them and the responses that I've got, my lord.
Akuzange kube nesinqumo esathathwa ukuthi sonke sizobona kanje. Futhi ke mithina ke umsebenzi wethu ukuthi kwakuphenya sithole sikutholayo ebese sikudlulisela kubona. Kube yibona ke abathatha isinqumo sokuthi lolu daba lolu bayadlulisela inkantolo. Uma ukuthi khona obulunye uphenyo abalidingayo, yebo sasikwazi ukuqhubeka kanjalo kodwa akukho okunye engachaza ukuya phambili ngalokho.
Thank you, Brigadier. Let us embark upon a standard 3 approach. Was it part of the prosecutors who were assisting you? Was it part of their narrative that accused number 1 is involved in the commission of this case?
I beg your pardon?
Of a standard 3 approach. We submit, my lord, that the court has referred to the case of
yeah, I thought that case I gave you guys.
Azaf, and we
here's a
thought,
brigadier.
Yes.
It's being referred to as a standard 3.
Yes, and
You must approach him like a standard 3.
No, with due respect,
Okay,
that
I'm
is
not
what
going
I'm
to argue
saying.
that point. That's how I view it.
Yes, but my lord,
Let's resort to a standard 3 approach.
no, I am saying, let me take it step by step so that we understand each other. But I'm not saying that the brigadier is a standard 3, my lord. I would not have intended to say that. I am saying, let us simplify my question in the following sense. Brigadier, let me put it this way. Let me simplify my question let's not make meat out of the fact that, let us not make a mountain out of the ant small that are set, let us have a standard 3 approach. But what I intended to convey to you is that let us take it step by step. Maybe language is it's failing me. Thank you, Brigadier. But if you feel a little bit disrespected, my apology in that regard. Thank you, Brigadier.
Understood, my lord.
Thank you. Let us take it step by step. Now, was it part of the narrative of the team of prosecutors who assisted you that accused number 1 is complicit in this case?
Futhi kwaku umbono wo beshushisi bonke abanensizana nabo ukuthi umsola uqala naye ke wayethinteka kulolu daba.
My lord, accused number 1 has been charged. What is the relevance of that question?
I understand accused number 1 was charged, but was it part of their narrative that accused number 1 is complicit in this case? Yes or no?
Funa ukwazi ukuthi ke kwakuyindlela ababona ngayo yini ukuthi ke umsola uqala naye wayethinteka kulolu daba.
My lord, perhaps to assist, I'll answer it this way.
Yes.
All the accused, 1 up to 5, when the memorandum was taken to the DPP,
Yes.
there was a decision to indict all of them on the charges, on the 5 charges that are before court, as per the indictment. That decision was taken. Insofar as Ms. Kumalo, further instructions were given for me to do. And that is why the statement I read here in court, where I was directed by Mr. Ramsipili, stated the date of November 2014. It was part of those further instructions to say, follow these instructions and then bring it back. And then subsequent to that, then the warrant was not signed. But there was never an objection to say we should not pursue this. I don't know if it will assist, but I will not be able to quote word for word as we're sitting there what the advocates were saying. But there was a desire to say, let us get more evidence to connect. Hence I said, my lord, before this accused appeared in October, we had some evidence against Ms. Kumalo, which I've explained in this court. Later in November, we had more. We even dealt with the cell phone numbers. That was part of the prosecutorial driven investigation. So there was a working together between myself and the prosecution. But insofar as the ultimate decision to prosecute, my lord, that lies in the hands of the NPA. And I think it will be dangerous for me to venture into that area as to what informed them. But there was a working together in terms of what should be done with regard to the evidence or the pointers that implicate Ms. Kumalo.
Thank you.
Isinqumo esaphuma sokuthi ke umsolo uqala ukuyofika kwesihlanu bangathweswa amacala, kodwa ke akuzange kuphume incwadi ephuma kwa DNA echaza ukuthi ke kufanele kusetshenzwe kanje, kodwa ke kwaphuma ke enye ke instruction evela eyalethwa kumina mayelana noKumalo. Kodwa ke into eyikhona nje ukuthi sasifanele siqhubekele phambili senze umsebenzi wethu. And ke isinqumo ke esavela ko prosecutor esasivela ku NPA, and thina sasebenzisana nokuthi sizama ukuthi sithole ubufakazi obungasiza ukuthi sizwisise kahle indaba kaKumalo.
Yes, my lord.
I'm still struggling to get my answer on whether or not the fact that Kumalo is a kingpin in the matter of Senzo Meyiwa was part of the narrative that the team of prosecutors, actually let me not say the team of prosecutors, but the office of the DPP Pretoria had when they decided on this matter. I haven't received my answer. And I don't know what is the difficulty in saying, yeah, no, DPP Pretoria was of the view that Kelly was a kingpin in this case. However, she could not be charged because of this and this and this. That would have sounded better. But to simply decide not to answer my question, clouding it with a whole lot of lengthy explanation, I really don't think that assisted the court, but nonetheless, I realize that there's an objection from my colleague.
As a court, please, my lord, and we don't want to belabor this point. The witness is clear that the discretion to charge lies with the Director of Public Prosecution. He presented a memo, and the decision was taken by the Director of Public Prosecutions. He cannot take it any further. He said, he cannot, as he put it, go into the minds of, the Office of the Director of Public Prosecutions. I think my learned friend will unfortunately have to live with that answer.
And unfortunately, I am not prepared to live with that answer, but I do realize that it's a very difficult one. But nonetheless, let me proceed. The reason why I am asking this, it's because in terms of the law, when a person gets indicted at the High Court, in terms of Section 144 of the Criminal Procedure Act, the state must inform the court the facts upon which they are basing their allegations against those that they have indicted before court. That is law, which is the reason why I am asking you that question. Do you understand?
Usho ukuthi isizathu ke ukuthi ngibuze kanje ukuthi ke ngaphansi ka section 104 umthetho ubugebengu ukuthi ke umshushisi ufanele ayitshele inkantolo ukuthi yini indaba befuna ukuthi bathwese umuntu amacala futhi basebenzise ziphi izathu.
My lord, I understand. However, and I go back again, my part as an investigating officer, and exactly that, my lord, was done, and the matter, it's a question of separation of powers, and I've explained this, my lord. The docket was taken to the DPP, as is normally done, for a decision. A decision was taken. Now, for me, my lord, it's not a difficulty, but I can't speak on behalf of the NPA. It's separated, my lord. I did my part. I produced the evidence that we had insofar as this accused and what pointed to Ms. Kelly Kumalo. It's a normal, that's how it's done, my lord. You present it to the NPA, then they will communicate their decision to you as they've done in this instance. Now, I'm not sure, my lord, how do I then speak on behalf of them? I think the NPA in this situation, my lord, are better vested with the knowledge of giving Ms. Advocate Mnisi the answers that is seek, because I can't speak on their behalf, my lord.
Mina ke into indlela engizwisisa ngayo ukuthi umsebenzi wethu ukuthi njenge umuntu ophenyayo siyaphenya thina and mase siqedile ngale sithatha le docket sidisa kwa DPP uyena uzothatha isinqumo sokuthi uqhubeka kanjani. Angikwazi ukwakhulumela abaka NPA ngoba thina owethu umsebenzi phela ukuphenya mase siphenyile bese sidlulisela kwa DPP ibona abathatha isinqumo and futhi angikwazi ukuthi ngibakhulumele ibona abangasikhulumela ukuthi indaba ethatha isinqumo esinje.
Same with the section or the law that Advocate Mnisi referred me to. I'm not sure, my lord, how best can I assist him there. I mean, that lies between him and I think the court and with greatest respect, the Advocate Baloyi, because what do I say, my lord? That's not my terrain as well.
Futhi ke nangumthetho ayikuyafana nalapha akukho mina engakwazi ukusho ngoba akuyona into engathi ngifanele ngingenelele leyo angayikhuluma mhlambe ke no Advocate Baloyi kodwa mina ngikwazi ukuyingena leyo ngoba akuyona indawo engisenzela kuyona.
Yes, my lord.
Now, you're mentioning that you investigated the docket, you gathered all the evidence and presented it to the state. Now, was it part of your, before I get to there, and then after submitting that document, then the state went on to make a decision to charge the 5 accused persons that are before court here, and they gave you instructions to go and issue out warrants of arrest against them, not so?
Manje-ke emva kokuthi-ke uwenze uphenyo wakho uphenyo lwakho wathatha-ke le case wayisa-ke kubashushisi abashushisi bayibheka-ke base bethatha isinqumo sokuthi-ke bayaqhubeka nokuthi babathwese icala and emva kwaloko-ke istate-ke sasesibuya-ke sithi-ke sebengashashwa bangakhishwa-ke nama-warrant ukuthi bangaboshwa labantu akunjani.
My Lord, the first part is correct. A decision was taken and then an indictment was sent to me. I'm not sure if there was instructions to say go and get warrant of arrest. I mean, as I've said before, my Lord, J50s are a way of bringing the accused persons before court because a decision was already taken that, they're indicted for these charges. I then took that route, my Lord, of applying for J50s as per the affidavit that I disposed, and then that was solely granted, my Lord, and then the accused were brought before court.
Lokho kushilo ekuqaleni kuyiko kodwa-ke okwesibili akunjani ngoba zange kube nama-warrant of arrest noma iy'ncwadi zokubopha ezakhe. Thina-ke esacela nje ukuthi sicela ama-J50 ngoba iwona esawasenzisa ukuthi abantu abalethwe enkantolo njengoba ngishilo kwa-affidavit yami.
Thank you, Brigadier. Further, I think that part of the instructions in that indictment was that they should be arraigned for trial in the High Court.
Futhi-ke kuyisa phambili lokho ukuthi kwathiwa abayiswe abahambe-ke beyovela enkantolo ephakeme.
I suppose, my Lord, I'm just not sure word for word now because I'll have to go through to the indictment, my Lord. But I suppose if Advocate Nisi saw it recently, I will not dispute that.
Ngiphikiseke lokho uma ukuthi u-Advocate Nisi akudala ekubonile anginaso isiqiniseko sokuthi kunjalo kodwa ngifake ngibheke.
Yes, that is how the decision should have been penned. But nonetheless, which is the reason why they are before court here. But my question, therefore, is, when you submitted that document, was it part of your investigation that you submitted to the office of the DPP that Kelly, before they took that decision, that Kelly Kumalo is also complicit in the murder of Senzo Meyiwa?
Manje musuzofaka izincwadi zakho kwa-DPP wakufaka yini nokuthi no-Kelly Kumalo yathinteka kuleli cala?
My Lord, yes, I presented all the evidence as it is, and as I indicated, part of my recommendation or request was that she should be charged, but then there were further instructions insofar as she is concerned at that stage, my Lord.
Yebo, ngafaka konke kulezi ncwadi engazifaka kwa-DPP and futhi ngasho-ke nokuthi naye ufanele athoswe icala.
And based on your investigation, you were satisfied that there were reasonable grounds to believe that there was a reasonable suspicion which you formulated based on your investigation to believe that she is or was complicit in the murder of the deceased.
Ukuthi wena-ke wawenelisekile ngokuthi-ke uyasoleka naye and futhi-ke wawukholwa ukuthi kufanele naye athoswe icala.
Yes, I was, my Lord.
Thank you.
Yebo, kunjani.
Now, this is what the state told this court in terms of Section 144, subsection 3A of the Criminal Procedure Act, which is called the Summary of Substantial Facts. And I'm going to read it paragraph by paragraph. It has got 12 paragraphs, but I'll try to be very brief and very precise. This is how it reads.
Once again, what has got the summary of substantial facts to do with the witness? The witness gives evidence, said he presented the docket to the DPP and the DPP exercises discretion. If my learned friend has got the legal argument to make out of summary of substantial facts which are not binding on the state, it's for him to present that argument to to the court and not to this witness. We submit that his current line of cross-examination, my lord, is irrelevant as far as this witness is concerned.
As it is the court, my lord, I think that is, it's a misdirection, it's a misrepresentation of fact. It can't be had to be said that an information that relates to the investigation of a case wherein an investigating officer is under oath and is taken up on his investigation, then it is argued that that line of cross-examination is irrelevant. What is it that I am coming up with which does not have to do with this case in my line of cross-examination? I dare my colleague to stand up and say, in terms of what you have said now, has got nothing to do with this case, then I would say, yeah, no, they are making a mistake. But everything that I've said so far has got everything and anything to do with this case. I've never spoken about anything that has got nothing to do about this case. Unless, of course, the guilty are afraid, I would understand. But up to thus far, there is nothing that I've come up with which has got nothing to do with this case, madam. Definitely.
Yes, Mr.
Well, I don't know what daring and the guilt refers to.
Maybe
but
let's read section 104.
yes. But such obnoxious comment notwithstanding, my lord, we submit that this witness testifies about the course of the investigation, what the DPP has decided, and what the Director of Public Prosecution has formulated in the indictment, in the summary of substantial facts, has got absolutely nothing to do with this witness. And it was on that basis, my lord, that we made the submission that this line of cross-examination is relevant to this witness. He was not party to the compilation of the summary of substantial facts and the indictment. And we don't want to repeat ourselves, my lord, but we submit that that line of cross-examination should be disallowed. Did the court say I must read our section
so that's it.
144?
People understand what we are about. Because we're quoting sections which maybe some people are not even aware what they say.
Right.
I mean,
The heading to section 144 is charge in superior court to be laid in an indictment. It's a very long section. I'll read the whole of it. Subsection 1. Where an Attorney General, now the Director of Public Prosecutions, arraigns an accused for sentence or trial by a superior court, the charge shall be contained in a document called an indictment, which shall be framed in the name of the Attorney General. Subsection 2. The indictment shall, in addition to the charge against the accused, include the name and, where known and where applicable, the address and a description of the accused with regard to sex, nationality, and age. Subsection 3A, where an Attorney General under Section 75, 1213B or 1222 Roman figure 1 arraigns an accused for a summary trial in a superior court, the indictment shall be accompanied by a summary of substantial facts of the case. That is what we are currently debating. A summary of substantial facts of the case that, in the opinion of the Attorney General, are necessary to inform the accused of the allegations against him and that will not be prejudicial to the administration of justice or the security of the state, as well as a list of the names and addresses of the witnesses the Attorney General intends calling at the summary trial on behalf of the state, provided that, Roman figure 1, this provision shall not be construed that the state shall be bound by the content of the summary. This is the point that we've just made. Roman figure 2, the Attorney General may withhold the names and address of a witness if he is of the opinion that such witness may be tampered with or be intimidated, or that it will be in the interest of the security of the state that the name and address of such witness be withheld. Roman figure 3, the omission of the name or address of a witness from such list shall in no way affect the validity of the trial. In this matter, there were certain names that were omitted. Roman figure 3b, where the evidence for the state at the trial of the accused differs in a material respect from the summary referred to in paragraph A, the trial court may, at the request of the accused, and if it appears to the court that the accused might be prejudiced in his defense by reason of such difference, adjourn the trial for such period as the court may seem adequate. Subsection 4, Roman figure 1, an indictment together with a notice of trial referred to in the rules of court shall, unless an accused agrees to a shorter period, be served on an accused at least 10 days, Sundays and public holidays excluded, before the date appointed for the trial, the Roman figure 1, in accordance with the procedure and manner laid down by the rules of court, by handing it to him personally, or if he cannot be found, by delivering it at his place of residence or place of employment or business to a person apparently over the age of 16 years and apparently residing or employed there, or if he has been released on bail, by leaving it at the place determined under section 62 for the service of any document on him, or Roman figure 2, by the magistrate or regional magistrate committing him to the superior court by handing it to him. Then subsection 4b, a return of the mode of service by the person who served the indictment and the notice of trial, or if the said documents were served in court on the accused by a magistrate or regional magistrate, an endorsement to that effect on the record of the proceedings, may, upon the failure of the accused to attend the proceedings in a superior court, be handed in at the proceedings, and shall be prima facie proof of the service. Then lastly, subsection 4c, the provisions of section 55, 1 and 2 shall mutatis mutandis apply with reference to a notice of trial served on an accused in terms of this section. So, Malo, this simply buttresses the point that was made by the state earlier on, that the DPP, in his opinion, has set out a summary of substantial facts, and this witness can be of no assistance as far as that is concerned.
Yes, let's hear you, Mr. Minister.
As it please the court, madam. May I respond?
Hello?
I'm saying, may I respond?
No, you must address me on the law, because you
That is what I'm saying, madam.
Also, you're saying?
I'm saying, may I respond?
Yes, yes.
Yes. I think my colleague is running away from telling the court about what you read being a prejudice.
What?
prejudice to the accused. These accused persons, my lords, have been arraigned to this court to answer the allegations that are contained in the summary of the substantial fact. And there is nowhere in the summary of the substantial fact where Kelly Kumalo is mentioned as a kingpin. Instead, in the summary of the substantial fact, Kelly is mentioned as a victim. Now, all along, throughout the testimony of Brigadier Kininda, Kelly Kumalo is branded as the kingpin, the person who organized the killing of the deceased, which is the reason why I am asking if at the very inception, at the drawing, at the preparation of the summary of the substantial facts, the state was aware that Kelly was a kingpin, so that when it decided to draw this summary of substantial fact, that should have been a factor to be taken into account, so that when these accused persons come and answer on the allegations that are against them, they know that amongst others, we are before this court to answer allegations that we were in consort. We worked together with Kelly Kumalo to assassinate Senzo Meyiwa, and that is not there. They are now expected to answer on something that was initially not put to them at the beginning of the trial. Remember, my lord, when the charge is being put against this accused person, the summary of the substantial fact is also read into the record. That is part of the charge sheet. There is nowhere where they were called upon to come and answer that they worked together with Kelly Kumalo. That is the reason why I am basically asking, and I'm not trying to indict any person. I'm getting somewhere with this line of cross-examination as to whether or not at the preparation of this indictment was the state aware that Kelly Kumalo, such a very, without Kelly Kumalo, would not have been here basically. As per the testimony of Brigadier Kininda, we would not have been here because accused persons would not have had anyone to come. According to the allegations of Brigadier Kininda, these accused persons would not have had anyone to entice them to go and kill Senzo Meyiwa. But that is not contained in the summary of substantial fact. It doesn't matter, my lord, whether a person is charged or not charged, but the summary of substantial fact must contain the information that is contained in the case docket, so that when the accused persons are confronted with that allegation, they are able to respond accordingly. And that has not happened in this case, which is the reason why I am compelled to find out, because now they are expected in the middle of the trial to answer to something that has not been there at the inception of the trial. There's nothing wrong in me finding out whether or not at the time at which the decision was made, the state was already aware that Kelly Kumalo was a kingpin.
But you're arguing something different.
No, okay, my lord, let me hear. When the court says it's different, in what way, my lord?
No, let's play your question first, because you're into the merits, etc.
No, I'm responding to the state, my lord.
What were you responding about the irrelevance of this witness being cross-examined on the content
Yes,
of the indictment,
yes.
which, according to you, you're saying it's not
Yes.
relevant for this witness because it is the
Yes.
Director of Public Prosecutions
Who
drafts
decides? Yes,
the indictment, including even that panoply of facts.
yes.
And that you also say that, but even that also doesn't bind the state.
Yes.
I thought that was what we were talking about.
Yes.
Now we're talking about Kelly Kumalo.
No, my lord. The Director of Public Prosecution, yes, does draft an indictment, but he's drafting an indictment based on what facts?
No, fine. You
Who
can
brings the
argue-
facts to them?
Mr.
Yes.
You can argue those facts. But if you read that act,
Yes.
it says in
The section.
It
Yes.
says in the opinion of the Director of Public Prosecution,
Yes.
not this witness.
That is correct, my lord. But now, if it is in the opinion of the Director of Public Prosecution and
Yes.
the witness includes something which in the opinion of the Director of Public Prosecution has not been included here, must we then fold our arms and say no? Because the Director of Public Prosecution has decided not to include this, we should also not take this witness on
you
that
should have-
evidence.
then you should have requested further particulars.
But that we did
No,
not.
no, that's the procedure.
Yes.
Am I correct, sir?
Yes.
Otherwise we'll be here the whole day. When
Indeed.
you are hit with, your client is served with an indictment,
Yes.
you've got a right to request further particulars and further and better particulars. Did you do that, sir?
Let me respond, my lord.
Yeah.
Yes.
Yeah, fine.
There is no way where in the indictment it is mentioned that Kelly Kumalo is a kingpin. Had that been mentioned from the onset, we'll definitely have requested further particulars. There is nowhere in the indictment where it is mentioned that Kelly Kumalo is a suspect. Instead, in the indictment, it is specifically mentioned that Kelly Kumalo is a witness. How could we then have been enabled to request further particulars when we did not know that Kelly Kumalo, in the mind of the investigating officer, Kelly Kumalo is a kingpin?
But Kelly
This-
Kumalo, sorry.
Yes.
Kelly Kumalo is not charged in this court. I don't see her.
Yes, she is not charged, my
Yeah,
lord. But
so
the fact
why should I respond to that? I only respond to persons who are charged.
that is
Where
correct.
there's litis contestatio
Yes,
between the accused and the state.
Yes,
Kelly
ma'am.
Kumalo, I don't know.
Yes, my lord. Her not having been charged, my lord,
Yeah, you can argue that.
it's not
Okay,
it's not
ask that very question
I-
to this witness. Every question you want to ask him, ask him.
My lord,
May I request a short adjournment, my lord? It's already tea time. I think it's already 11:15. May I request a short adjournment? In any event, I also need to respond to the call of nature as well, my lord. I come and pursue this point when I come back. Thank you, my lord.
Yes,
my
sir.
lord, my lord, before we adjourn,
I'm
with due respect, my lord, for the sake of...
nature, you know, it's killing me.
Okay, 15 minutes. Where's Mr. Cholo? You wanted to say something before adjournment?
My lord, it's just on the point of clarity.
Clarity.
Yes, my lord.
From whom? Me?
From the court, my lord.
Oh,
Yes.
I
My
thought
lord,
you were-
it's in respect of the provisions of section 144,
Yeah.
which has just been read here
Yeah,
in court. And the reason why I'm standing up, my lord, I will just read subsection 3 only
Yeah,
of
right.
section 144, which says when Attorney General under section 75, 121 subsection 3, B or 122 subsection 2(1) arraigns an accused for a summary trial in a superior court. The indictment shall be accompanied by a summary of substantial facts
Yes.
of the case that in the opinion of the Attorney General are necessary to inform the accused of the allegations against him.
Yes.
So, my lord, my submission is that if the indictment, inclusive of the substantial facts, have been served and read into the record.
Let's keep one thing clear.
Yes, ma'am.
That summary of facts doesn't bind the state. You can't. Am I right, sir?
Yes, indeed. That's what we've placed on.
Yeah, that's
on-
what's
on
critical
record.
because we're reading evidence now. We're including evidence in our argument.
Can I
The
finish?
charge sheet just says you are charged with murder in that on such and such a day you killed Ratamukwatle. Fine.
My lord,
Okay, go
Can
on.
I finish?
Yeah,
ma'am?
finish.
Thank you. And it says, allegations against him and that which are necessary against him and that will not be prejudicial to the administration of justice,
Yes. Fine, no problem.
or a security of state as well as list of the witnesses, addresses of the witnesses and the general and the Attorney General intends calling at the summary of the trial on
Right.
behalf of the state.
Yeah.
My lord, my submission is that as much as the summary of facts and the indictment, it's not binding to the state.
Right?
But it forms part, the substantial facts forms part of the record because they are read into the record. And the purpose of the substantial facts to be read into the record is to inform the accused of the allegations against him or her.
Yeah.
Then my submission, my lord, is that then if on the list of the substantial facts, there is a fact in which the
It's a fact or an allegation?
it's an allegation, my lord.
Yes,
Can I just rephrase it?
Yeah.
Yes. There's an
That's it,
allegation.
yeah.
Specifically, wherein it refers to Ms. Kelly Kumalo as a complainant.
Is she a complainant?
My lord, I'm saying as is referred to here in paragraph 5, my lord. My lord, then my submission is that the defense should be allowed to seek clarity to the witness on the issues that appears or on the facts that appears on the substantial facts, my lord.
Okay, fine.
Can we maybe just have
Yeah.
another bite at the cherry? If my colleague is done.
Yeah, it's through. She's through.
Okay. My lord, we just want to raise a point of procedure. My colleagues are at liberty to raise any point, to argue any point. Section 85 was at their disposal to object against the charge sheet. Section 106 was also at their disposal.
Yeah.
Now we're busy with cross-examination, and now legal arguments have been raised in cross-examination. My suggestion, if they have any legal points to raise, they're at liberty to do so, to ask for an adjournment, to formulate such legal arguments. But at this stage, my lord, we submit that we are busy with cross-examination, and we should then focus on the cross-examination. If anyone wants to raise legal points, they may do so, file heads of argument, on which, we'll all respond. That is the
Yeah,
state's
fine.
suggestion.
You know what? I don't want to be accused of being unfair, even if I understand the law differently from what is being argued here about the merits. I'm here to decide on the merits. The arguments, I've got to listen to them, fine. The evidence, I've got to listen to it, and also thereafter decide whether the state has proven its case beyond a reasonable doubt. But you know what? You can ask this witness anything you want. Mr. Nis, anything you want. Anything.
No, my lord.
I'm talking like you. When you were proposing that there's nothing which you have touched which does not concern the case. So you
Yes.
can ask anything you want about the case. Okay, fine. That's my ruling.
As it is the
Yeah,
court, my
fine.
lord. But again,
No, I've just ruled. Otherwise, we'll be here the whole day.
yes, my lord, but I'm saying I also have to be informed by the fact that whatever I'm asking this witness, even if it is part of the case, it must be relevant.
No.
Yes.
You can ask anything you want of this witness, please. Because
Thank-
when we come to relevancy,
Yes.
then you may have problems, like your learned colleague is saying. He's saying what you're asking is irrelevant because it is the Director of Public Prosecution who formulated that document and took a decision to charge the 5 gentlemen in front of us.
Yes, my lord.
So please, just go on then.
But I think that objection loses sight of the fact that it is very same witness who introduced the notion that this case is prosecutor driven by the Office of the Director of Public Prosecution, my lord. But nonetheless, I realize, Brigadier, thank you. I realize that apparently I'll not be in a position to get the answer to whether or not the Office of the Director of Public Prosecution was privy to the fact that Kelly is a kingpin when they decided to take a decision in this case. That I'm comfortable with. But nonetheless, let us proceed. Now, in terms of your testimony, you are mentioning that it's just a recouping, that Kelly is a kingpin, not so.
Ufazini bakho uthi uKelly uyena ohamba phambili ukwenzeni ekudaleni leli cala.
Yes, the evidence, my lord, that we collected suggests that she's a trigger point.
Yebo ufazi sibutholile ibona benza sibone ukuthi konke kusukela kuye.
Now, in terms of your investigation, could you find any motive why Kelly would have wanted to kill Senzo?
La ekuphenyeni kwakho wathola yena ukuthi ngabe kuyisiphi isizathu sokuthi afune ukubulala uSenzo uKelly?
No, my lord, we looked at a number of things. I mean, that is why the court will recall we even read the messages between her and the sister. But to say we found one specific motive, my lord, we've not got that. We are not there yet, my lord. We are still investigating anyway.
Sisaqhubeka nokuphenya angeke ngisho ukuthi ke kukhona isizathu esisodwa singathi isona anaso kodwa ke ziningi izinto esizibhekile sibheke saphinda futhi sabheka nemlayezo eyayithunyelwa phakathi kwakhe nodadewabo kodwa ke angeke ngoba saqhubeka nophenyo asikafinyeleli kuloko.
Thank you, sir. What is prompting all this question is because as I listen to the evidence of the people who were in the house, Madlala, Longetwala, Zandile Twala, Zandile Kumalo, yes, I'm sorry, Zandile Kumalo, basically those are the three people who testified were in the house. They said, upon Senzo being, and I'm not here to plead Kelly's case, but they said upon Senzo being shot at, Kelly was very hysterical. She assisted in loading the deceased into the vehicle and she drove like nobody's business. She drove like mad trying to rush the deceased to the hospital. And then something says to me, okay, but then you can interpret Mr.
Manje ke lokhu okushwa uMadlala noLongethwala noSizande Kumalo kuthiwa ke uKelly wayekhala kakhulu ngesikhathi ke eselinyaziwe uSenzo kuthiwa wasiza ngokuthi asize nokuthi uSenzo afakwe emotweni futhi ke washayela ngesivinini esikhulu.
Now, and at the hospital there, she defied procedures with a view to try that Senzo should be assisted as quick as possible.
Futhi nasesibhedlela ke wafike wacela ukuthi asizwe ngokusheshsha.
Now, something comes to me and say, but the investigating officer keeps on telling this court that, look, Kelly is a trigger point. But what could have been the motive for her to kill Senzo? And again, immediately after Senzo was shot by the bullet, okay?
Futhi ke njoba ke ngizwa lana ukuthi ke umseshi uthi yena uKelly uyena obehamba phambili kubulaweni kaSenzo. Kodwa ke isizathu angisitholisisa ukuthi ngabe kuyini isizathu sokuthi afune ukumbulala.
And again, after having been hit or struck by the bullet, Kelly did not waste any time. You know, they bundled the deceased into the motor vehicle and drove at a high speed, that is according to Long, drove at a high speed to the hospital. Is that conduct really compatible with the conduct of a person who wanted another person being killed?
Futhi ke emva kokuthi adutshulweke ngokusho kaLongethwala uKelly wazama ukuthi Senzo Meyiwa afakwe ngokusheshsha emotweni waseshayela ngesikhulu isivini lokho izenzo zomuntu obefisa ukuthi abulawe.
Now do you understand why I wanted to know whether it was the state's narrative from the inception of this case that Kelly Kumalo was the kingpin? Do you now understand?
Manje sizisa ukuthi yini ngithi ke mina bengifuna ukuzwisisa kahle ukuthi yini istate uKelly Kumalo uyena ohamba phambili ekuzameni ukuthi ekwenzeni licala.
So, my lord, I'll start with the last question. As I've said, I cannot speak on behalf of the NPA. I've said it. Decision lies with them insofar as the prosecution, and I can't really, even if I want, I'll be venturing into a terrain where I've got no authority, so I can't take it further than that.
Yes.
Docket was forwarded with all the evidence, including Ms. Kelly Kumalo, and I've indicated that no decision insofar as her position is taken was taken, my lord.
Uqala ngasho ngithi mina angeke ngikwazi ukukhulumela iNPA idocket yadluliswa iswa kubona efaka futhi noKelly Kumalo kodwa ngeke ngikwazi ukubakhulumela abeNPA.
I mean, her position is concerned, my lord. So now, with regard to the naming of Ms. Kelly Kumalo as the kingpin, my lord, the evidence, it is not my assertion. It is not me who stood up and said, now we're going to pursue Ms. Kelly Kumalo. I've indicated way back, my lord, that initially when we started this investigation, it looked like it was a robbery gone wrong. After, obviously, we dissected the docket and concluded that they were intruders. The evidence that was before us at the time when I started the investigation, it looked as if they were intruders, and during the robbery, who were intending to rob, and then things went wrong and the deceased was shot. That's what the evidence was pointing at the time. Fast tracking forward, my lord, getting to accused number 1 and subsequent accused number 2, the picture changed, where it, for the first time, the name of Ms. Kelly Kumalo came in as a trigger point. Now, when you investigate, you can't ignore that fact. That is where now the investigation, insofar as Ms. Kelly Kumalo comes in, then the exhibit JJ and HH with regard to accused 2 kicks in, and then the name again is mentioned of Ms. Kelly Kumalo as trigger point. Then the investigation goes further and further and further, and all manner of things that I spoke about, my lord, in terms of the links, the cell phone, which I said it could not be. As I was investigating, remember now this allegation is being made. Now I'm trying to find collaboration to say, could this be true or false? And if we found that it was not supported, my lord, yes, we're going to make a finding that this is not true. But then the investigation then revealed, in terms of the experts that we brought in, insofar as, for example, cell phone analysis, that says, I can establish the link between accused 5 and Ms. Kelly Kumalo with regards to those 2 calls. We've dealt with that. Then he comes in and says, but I can also find the see-through bag between accused 3, the see-through bag that is a common link between accused 3, Ms. Kelly Kumalo in specific, because I'm talking to her, and the other links that that I'm talking about, my lord. Now, if you take that collectively, and I've also touched base on the issues of the cell phones, which at the time of the offense were not disclosed to the police at the time, because we're now trying to find collaboration, whether there is substance in what was suggested in the confessions. You find all these facts, my lord. You cannot now ignore those things and say, no, it's not true. Evidence that was collected, not my thinking, evidence that was collected supported that there was a trigger point from Ms. Kelly Kumalo, and that's what the evidence said, my lord, emanating from the confessions of both accused number 1 and accused number 2, because that is where the name of Ms. Kelly Kumalo started, not before that.
Engakusho-ke manje ukuthi-ke ukuze sifinyelele lapho esathi khona Kelly Kumalo uyathinteka, akuyona into esho yimina, kodwa-ke ekuqaleni kokuzwa ukuthi kukhona ubugebengu obenziwa lapha, ngoba khona babezama ukungena bayobamba inkunzi, nokuthi kwakukhona abantu abakhona. Eqaleni thina sasibona sengathi yebo kwakubanjwa inkunzi, nokuthi kwakukhona-ke ababangenela lapho, nokuthi-ke khona uwadutshula lapho. Sasicabanga ukuthi wadutshula ngoba kuwukuthi ngesikhathi bezama ukubamba inkunzi khona okungahambanga kahle. Kodwa-ke uma sesiqhubekela phambili, sesithatha nomfazi womsolo wokuqala nowesibili, sesiqhubekela phambili necala, kuyabonakala, kuyavela ukuthi hayi bo uKelly ngathi naye uyathinteka khona lapho. And mase sifaka futhi nembukiso uJJ no HH, kuyabonakala ukuthi cha uKelly ngempela ingathi kukhona ukusola ukuthi ngabe kuyena ohamba phambili kuleli cala. Na ukwabe kungelona iqiniso, bengeke kube inkinga ukuthi sisheshe sibone nakhona ukuthi hayi lona impela akukho lutho olumhlanganisa naleli cala. Kodwa ke ekuqhubekeni nokuthi sifune ukuthi sifunisise siye phambili siphenye kwaqala ukubona yabona izinto ezinjengesikhwama lesi esatholakala isiphoma leso okwazi ukubona ngaphakathi kwaso esasibonakala usatholakala efonini kaKelly nasefonini kaMsolo wesithathu kona kwasiqala ukusenza ukuthi siqala ukubona ukuthi cha khona izinto engathi ziyaxhumana la angeke sikwazi ukuziba ukuthi siyabona ukuthi khona izinto ezibonakalayo la ukuthi hayi uKelly ngathi uyathinteka and okukhulu nje okwasinika ukuthi sibe nalowo mqondo ukuthi yiloko kwavela ekakhulukazi emafonini komakhalekhukhwini.
Yes, my lord, I just want to put this into correct context. When I said this is where the name Kumalo came up, I meant to say when her name was now labeled as a mastermind. That's the right context I want to put it.
No, engifuna ukuchaza ukuthi ukuthi lavela kanjani la ebengizama ukuchaza ukuthi lavela kanjani ilona igama lakhe njengowayo ingqawo phambili kulokhu ekuzameni ukulungisa ukuthi ayodutshula uSenzo.
So in essence, my lord, what I'm saying, you cannot now, as much as I hear what Advocate Mnisi is saying in how it was described, Ms. Kumalo acted after the incident up to when the deceased was taken to the hospital and whatever transpired at the hospital. After this allegation then came up in the confessions, investigations were done, and this investigation, my lord, revealed what I've tabled before court. And in the search for the truth, I could not, as I'm standing here, I could not find a reasonable explanation or justification as to why, for example, and I'll deal with the calls, what was the relationship between Ms. Kumalo and accused 5? And what was those calls were about in terms of relations? Because remember, she was a public performer, a singer. It could have been that, for example, they are related, or there was some transactions of some business that they were doing together. I could not find the legitimate reasons for that transaction. I could not, up to today standing here. I could not find reasons as to why there were these similarities in terms of the picture of the money appearing in the photo downloads of accused 3, as well as the one of Ms. Kumalo, and to be fair, the one of Long as well. I could not find reason, my lord, as to why the 4 numbers that were picked up by an expert to say they were existing on that day, because I've explained, my lord, that the issue of the numbers came in when I wanted to establish, because when you follow the confession, it is said one of the accused were constantly talking to Ms. Kumalo or referring to her as sisters. And I've indicated that, my lord, that when you were looking at the numbers that were known to the state, these 2 numbers, the one that was alleged to have been robbed, which was robbed and was picked up by Muleleke section, and the one that remained, which was downloaded, we could not find those linkages. We could not find calls that would have come from these accused, except the calls of the 2 of August and the 15th of October on her number that came from accused 5. But the calls of that specific day, on the day of the incident, we could not find. And that then widened the investigation, which then revealed that there were numbers that she was using on that day. And unfortunately, because the police were not aware at the time, could not get those numbers, and that link could not be established, my lord. When we came to know about them, the window period, as I've said, my lord, had passed, and we could not get the actual handset to actually do the download. Now, if you take this fact that I've just mentioned, my lord, or these that were revealed by the investigation, you cannot ignore the fact that there is something untoward, and that is why I then made the application for the J50 in terms of section 43 for Ms. Kumalo to be added as one of the accused, my lord.
Yebo ngikuzwile ukube kukhulunywa ubaba uMnisi ukuthi ke uKelly Kumalo waziphatha kanjani ngesikhathi uSenzo Meyiwa esibhedlela. Ngiyakuzwa lokho. Kodwa ke khona into engesakwazi ukuyiziba ubufakazi esihlangana nabo. Mina vele bengakwazi ukuthi ngithi ngingayithola ukuhlobana kukaKelly nomsola wesihlanu ngoba mhlambe ke asazi mhlambe babe yihlobo o mhlambe babazana ngebhizinisi kufika namhlanje angakwazi ukuthi ngitholisise lokho kodwa ke ukuthi kwakukhona isithombe esifana nayo esisefonini kaLongo ethwala umsolo wesithathu nokhe asingeke sikuzibe lokho futhi ke nokuthi ke umsolo wesithubili waletha i-confession and nokuthi ke futhi ke la eqoqeni abasola babebiza uKelly Kumalo ukuthi sisters kuyabonakala ngathi khona ukuthi ngathi bayamazi kodwa akazange sithole mhlambe ke amafoni aye ababeqhumana ngawo kodwa kwaba khona amabili nje mhla 2 August nomhla 15 ku-October and lapho ke ayikhuluma khona nomsola wesihlanu kodwa ngokubona ke kunjalo sabona ukuthi kungcono senabise uphenyo lwethu sizama ukutholisisa ukuthi ngaba kunani futhi olunye lungasisiza kodwa ke inamba ezazikhona sasingakwazi ukuthi singasebenzisa ngoba sasingenabo makhala ekhukhwini la bese singakwazi ukuthi singenza ama download bona ukuthi sithole ulwazi olungasisiza ukuthi siqhubekisele phambili uphenyo lwethu.
Yes, my lord.
Thank you, Brigadier. Now you mentioned that you could not find any reason why the same photos which were in accused number 3's, which were downloaded from accused number 3's phone, could be in Kelly's phone. You could not find a reason for that. That's what it just said.
Uthe wena anzani ukwazi ukuthola isizathu sokuthi yini indaba izithombe ezikwazi ukutholakala efonini kaMsolo wesithathu zaphinde zabona zisefonini kaKelly Kumalo.
Yes, my lord, but I'm referring to that in the context of the reasonable explanation. For example, let's say a similar picture is found between me and my colleagues who works with me. The reason could be that we've exchanged it. We've sent each other because we work together. I'm referring a reason in that context that I could not find a reasonable explanation in the course of the investigation as to why there will be these common features that are appearing, the links that the experts are referring to, my lord. I could not find, in other words, a reasonable explanation in terms of any relations between Ms. Kelly Kumalo and accused 3, as we are speaking about accused 3, my lord. There is no relationship that I found, whether in terms of her profession or his whereabouts, in terms of where he come from, homeland, phosphorus. I could not find anything that ties or indicates that these people know each other, and because of that, they could have shared certain things, my lord.
Uthi ke phela mina asizange sikwazi ukuthola ukuthi yini umsolo wesithathu enezithombe esifananayo nezithombe esefonini kaKelly ngoba yabona makuukuthi asithi ke mina kukhona izithombe ezisefonini yami nezomuntu esebenzisana nayo kukhona ke into engaba isizathu basebenza ndawonye kungaba nesizathu sokuthi mhlambe kukhona izinto ebezingaba semafonini abo bomabili kodwa ke lana sizange sithole sizathu sokuthi umsolo wesithathu noKelly kanti bahlangana phi bayihlobo mhlambe umsebenzini kukhona into esingathi yabaqhumi futhi nokuthi uhlala phi umsolo wesithathu akuzange kutholakale lutho nje olwenza ukuthi sithi kukhona ukuxhumana esingathi kungaba khona ngaleso sikhathi.
Yes, my lord.
Thank you, Brigadier. So, in your quest to try and find a reasonable explanation on your narrative, now, did you ever consider what I referred to you yesterday as a scientific invention being a boon to mankind?
Futhi ke wake wathola mhlambe incazelo yaloko ukuthi scientific inventions is a boon to mankind.
No, my lord. I mean, in fairness to Mr. Minister, no, I did not. But that's not how you investigate. You investigate and rely in the search for the truth. You do your best to find the truth, and with greatest respect, not assumption, because I would have assumed. I did not find. Remember, in this matter, my lord, I brought in experts from who works with cell phones. Now, if that was available for some reason or the other, I suppose then the expert would have said, no, this is the explanation as to why this see-through bag is found in these 3 phones. That's not what was informed, that's not the report I got from them. And I relied on that in moving on with the investigation. That's why I'm saying, other than that, me in the course of my investigation, I could not establish link beyond that as to why there will be this link, let me put it that way, not communication, link. Hence, as I've said, I did not find any relations between Ms. Kelu Kumalo and accused 3.
Ya kodwa emsenzini wethu sifanele sizame ukuthi sithole iqiniso, sifune iqiniso, singathathi nje esikucabangelayo, ngoba njengoba bengishilo mina ngasebenzisa ochwepheshe la, ochwepheshe bamafoni, and futhi ke nabo bathi mabebheka la emafonini abazange banginike ukuthi kukhona yini isizathu abanganginika sona esikhombayo ukuthi bafanele baqhumene kanjani umsolwa nokheli, and futhi akuzange kube nesizathu singathi singinikwa sona esamkelekayo kimi.
That's my answer, my lord.
Thank you, Brigadier. Let's proceed. Now, you had made a number of affidavits. In other words, you have penned a number of affidavits in this case, others with a view to request for certain information, to be allowed to access certain information, the 205 application, the what is known as the 205 applications. Also penned affidavits when you were applying for the warrant of arrest of this accused, not so?
That is correct, my lord.
Athi ke wenza ama affidavit amaningi lana phakathi kwawo kwakhona nalawo awayicelo zokuthi ukwazi ukuthi ke ufinyelele ulwazi oluthize into enjengamhlambe ke asithi isibonelo lapho ucela ukuthi ufaka izicelo zokuthola ama-205 and okunye ke ilawo ucela khona ukuthi ke ukwazi ukuthi uthole ama-warrant of arrest, kusho ukuthi incwadi ezigunyaza ukuboshwa kwabantu. Athi yebo kunjani.
Thank you. And the basis of those affidavits will be found in the context of investigation also.
Kusho ukuthi izathu zokuthi ufunela ubhalela ama-affidavit kuyatholakala lapho ekuqhubekeni nokuphenya kunjalo.
Yes, my lord.
Yebo kunjalo.
Thank you. Let us go down the trip memory lane and deal with each of those affidavits that you penned. Now, I'll just give you this paper that I have, just for you to confirm in a general term that these are your statements and everything. You see, I take it. It will be fallacious for me to be expected to say, is that your handwriting? Read back to you? Was it everything to you? You know, in terms of what the protocol relating to authentication of statements are. Let us just do it in a very intelligent way. I propose, I'm going to hand to you a document which is supposedly your affidavit. Just have a look at it and confirm whether this is your affidavit.
Nika ke affidavit ngicela ukuthi uyibheke usho ukuthi eyakho yini.
The first document is labeled A333. There it is, sir. Yeah. A333. A333. No, don't read my markings. Just
No,
identify the
I wanted to read. This is the part with my statement, so
Okay,
I want to
fine.
read the contents and understand if I make yeah.
You can be rest assured I'm not be asking those questions that you see being marked.
No, I just wanted to check the contents of it, my lord. Yes, it is my signature, my lord, and those are my details, my lord.
Thank you.
Athi yebo imina engiyesayindile lapho and futhi ke nemininingwane lapho iyami.
Thank you. Thank you, sir. Thank you. Now, this is a affidavit that was written to support an application that was directed to the magistrate to authorize an application in terms of section 205. Do you still remember that?
Yes, I remember, my lord.
Sasifanele sicele sikhase isicelo sokufaka section 205.
Thank you. Now, I am just wondering whether I need to read the whole document out or should I just dwell on the portion that I would want us to deal about, or it will be argued that I am ambushing you if I do not read the whole document so that you know the background of the document before I deal with those portions that I would want us to concentrate on. May I request the guidance from the court, madam?
No, I can't advise. He just told me that you're not going to authenticate the document in terms of the law prescribes you.
I never said that, madam.
I understood you to mean that.
Thank you, madam.
Yes,
Do you recognize this document?
yes,
Uyazi le document lesibhekile.
yes, I do, my lord.
Yebo ngiyayazi.
Do you confirm that this document was written by you?
Uyaqinisekisa ukuthi ke le document yabhalwa wuwe?
It was typed and signed by me, my lord.
Yebo i-typo yaphinde yasayinwa yimina.
And do you confirm the correctness of the contents of this document?
Futhi ke qinisekisa ukuthi konke kubhaleke kahle ngaphakathi kwale document.
Well, my lord, I'll confirm that it is my signature, but remember now here, my lord, it refers to numbers, for example, of the accused. So I don't have the profiling to refer them to you, but it is me, and I'll assume what I wrote here is correct because I'm the investigating officer, my lord.
Yebo ngizothatha ngokuthi ke imina engayibhala ngoba phela kukhona ezinye izinto ekufanele ukukhulunywa ngazo nezinamba la ngaphakathi.
No, Brigadier. It doesn't work like that. You just heard the court that if I do not properly authenticate this document, then it's going to be considered as a pro non scripto. So I want you to say, with a straight face and say, yeah, no, this is my document. It was penned by me. I stand by the information that is contained in the document. It was commissioned before me, and that is my signature. Otherwise, we will be moving in a I don't want to be moving on a slippery slope, so to speak.
Angifuni sihambe ngendlela eshibulikayo.
My lord, I agree. This is my statement. I've signed. It was commissioned by me. It was commissioned before me by my colleague. What I'm saying is that the statement refers to certain numbers.
Yes.
And obviously, I don't have the profiling to compare if these numbers are accurate. But I confirm it is my statement. It was signed and it was commissioned, my lord.
Ngiyavuma ukuthi statement esami sasayinwa yimina. Ngiyavuma ukuthi sakhomishina omunye engisenza naye. Kodwa ke inamba la ama profile lezi number angikwazi ukuqinisekisa ngawo.
Now that you are saying you are not able to confirm those numbers, how do you then advise that we cross that bridge? Because I want to go into the statement, but because you are saying you're not sure about those numbers, how should we then cross that bridge? Because I don't want later on to be to come and argue here, with a limping leg.
Manje-ke sizokwazi ukuqhubeka kanjani-ke nalezo zinamba uma ukuthi awusiqinisekisi ngoba
Probably we need to give you an opportunity to go through those numbers and confirm them.
No, my lord, we can proceed. I
Thank
mean,
you.
I confirm this is my statement. I signed it. All I was saying, and I'm saying this, I think, with fairness, Advocate Nisi can understand. I do not have a recollection of these numbers vividly to say this number I got it from here, this number I got it from here, because these numbers would have come from profile, because there's a list of cell phone numbers. But I'm not distancing myself from this statement because I signed it and it's commissioned, my lord.
cha singakwazi ukuqhubeka kodwa-ke engizama ukuchaza ngalezi nombolo ukuthi phela angisakhumbuli kahle ukuthi ngizothi le namba lena ngayithala lana le namba lena ngayithola lana le namba ngayithola lana yikona engifuna ukuveza.
Now, I'm also trying to think about the best way of doing it, whether I need to make copy available to the court so that as we proceed with the statement, the court is also able to follow what is it that we're speaking about and what paragraph are we. Which is the best way? Thank you. I'm informed by my colleague here that, I'm advised by my colleague that we can just go through the paragraphs. Thank you. No, just a minute, madam. Because I don't actually want to continue reading, and the court is not in a position to decipher where am I now reading. So, which is the reason why I'm trying to think in a loud way, the best way of actually to go about.
Was that document not handed up?
No, this one it has not yet, madam. But let me confirm with my colleague, but I don't think so. It has not, my lord. But at the end of it all, after we're done with this document, definitely I'm going to request that it should be handed in, my lord.
It will be handed up.
Yes, my lord.
Okay, fine. I mean, after you have said to this witness, he took an oath when signing that document.
Yes, my lord.
He read it, he understood it, and that oath is binding on his conscience. That's what the law prescribes.
Yes, my lord.
Yeah,
Yes.
we must put it to him, because next time I'll be excoriated in the constitutional court that I let in a document as evidence when it was not properly before me.
As it is the court, my lord. Thank you, my
Is
lord.
that not so, Mr. Ngamal?
Yes, it is.
Yeah.
Thank you, my lord. Now, Brigadier, this document, it's numbered very accurately. I think the first document is written A333 in bracket 1, the second one in bracket 2, the third one in bracket 3. That is just the Ronio form with regard to the application. Now, your affidavit starts in A333 in bracket 4. Do you see that?
Yabona yini ukuthi-ke i-affidavit yakho iqala kahle kahle ku-A444.
Now, as I'm saying, you made a number of documents, you've penned a number of affidavits of this nature, but now I am on this one that is dated on the 7th of December 2020.
Kumele ngisho sengishilo ukuthi wenze ama-affidavit amaningi lesi kuyona manje ile kamhla ka-7 December 2020.
Yes, my lord.
Thank you. Now, on page number A333 in brackets 4, let us go to paragraph 2. I'll call it paragraph 2, subparagraph 5. 1, 2, 3, 4, 5, yes. Where it starts with the sentence, the witnesses.
I see that, my lord.
Thank you. Now, it reads there, the witnesses stated that one of the suspects was carrying a firearm purporting to be a revolver. This accused was described as a black male with big eyes, dreadlocks, wearing a khaki or a brown jacket or top and a hat. He was shorter in height than the second suspect.
Yes, I see that, my lord.
Yes. Yes, I think you're doing the
No, I'll give him. He'll read from mine.
Oh, okay, no, thanks.
ngifunda yonke
Ngongolwesi.
uthiwa lapha-ke ufakazi lana washo ukuthi omunye walabasolwa wayephethe isibhamu ekucatshangelwa ukuthi sasiyivolovolo. Lo msolwa lona wachazwa njengomuntu onsundu onamehlo amakhulu nama-dreadlocks egqoke ukhakhi noma ibhantshi eli-brown noma i-top futhi egqoke nesigqoko. Kodwa lona-ke wayemfishanyana kulo msolwa wesibili.
Thank you.
Yes.
This is the description that you are conveying to the magistrate who had to approve or disapprove this application as being what you got from the witnesses, not so?
That is correct, my lord.
Atshile ngazolo lwayinika emantshi le wathi ufanele ufake lapha wabhala ukuthi ngazolo ukuthi wayenjani lo msolwa wathi yebo unjani.
Is this all that you got, Brigadier Kininda, about the description that you got from the witnesses who were in the house about the description of this person that you are now conveying to the magistrate?
Ikona konke yini wakuthola kuchazwa ababengikhona endlini mayelana nalabasolwa abantu bababona.
Well, I'm not so sure when you say all, my lord, whether is it all in terms of the statements of the witnesses, then the answer is no, because here I was summarizing. It's my statement summarizing what the witnesses have said. It was a summary, my lord. So you were not quoting the statement of each witness verbatim. It's not. It was my statement making an application and indicating what the witnesses have said. So you summarize, my lord.
Cha lokho akuzona izitatimende zaloko okakusho ilaba ufakazi bengitshela konke okwakuphuma emlonyeni yabo lana mina ngangifika nje kuphela lokho engangikuzwile bekusho.
But the essence of what is contained here, it is contained in the witness statements, my lord, that there were two intruders, one had dreadlocks, one was short, one was tall, was tall. The issue of the firearm, some witnesses do mention, that's why I said purporting a firearm to be a revolver, because we know that, we've dealt with this issue of the revolver and the expect, my lord. So it's a summary of what the witnesses who were in the house are saying.
Lokho ke okusho lana ukuthi ke kuyafana naloku kuphuma estatementini za labantu ababenginika incazelo ukuthi babenjani abasola estatementini zabo ukuthi ke nje lana kufingqiwe ukuthi ke babe babili nokuthi ke umunye nama-dreadlock khona umunye wayemfishane khona wayemude nokuthi futhi ke nale ndaba yevolovolo kodwa sesikhulumile ngendaba yevolovolo kodwa lana nje yilento ekuthiwa ngesilungu isamari ukusho ukuthi okufingqiwe.
Yes, my lord.
Thank you, Brigadier. What did the witness who were in the house say about the skin complexion of this person that you are describing to the magistrate in your affidavit?
Manje bathini ke laba ababesendlini uma bechazela ngebala lalomuntu abambona.
My lord, I've indicated that I think about 3 said dark, the other ones did not mention the color, the complexion, my lord. I think we dealt with that point, my lord.
Sesikhulumile ngaleli phuzu ukuthi abathathu abathi wayemnyama and then bese ke abanye abazange baphawule ngebala lakhe.
There was also a mention of dark brown, my lord. So, but the others did not mention that the first suspect was dark in complexion.
manje khona nje abathi dark brown kodwa ke laba abanye bazange baliphathe nomphathi ibala lakhe.
Thank you. Now, was it by mistake
Kwakuyiphutha yini lo?
that you decided not to tell the magistrate in your application or in your support of your application that this person that I am describing here, I was told by the witnesses, by 3 of the witnesses, that he had a dark skin. The other one, 3 witnesses said he had a dark skin. 1 witness said he had a dark brown skin, and the others were unable to describe his color. Was it by mistake that you did not include that in your confession? I'm sorry, in your affidavit.
Kwakuyiphutha yini ukuthi manje uma ufaka lesi sicelo sakho awuzange uyitshele manje ukuthi ke abathathu bathi unebala elimnyama amunye wathi hayi yena udark brown obanye ke bangaletha incazelo. Kwakuyiphutha yini
Please, my
kwenza
lord. I'm not sure what we're busy with now, but in any case, the witness says he gives a summary, when making this application to the magistrate. Must he now give such details as counsel would like him to have in trying to convey to the magistrate what the identity is all about, just to set out these minute details? We submit, my lord, that this is an unfair question, given the fact that this was just a summary in an application to a magistrate.
Thank you, my lord. It's very interesting, my lord. The objection of the state is based on the fact that it was not necessary for this witness to give those little niggling details about the description of or on the description of this suspect. But now, if you deemed it necessary and relevant to speak about dreadlocks, how could you not have deemed it necessary to speak about his skin color?
manje mawukuthi ke wabona ku semqoka ukuthi ke ungakhuluma ngama dreadlocks yini eyawenza ukuthi kungabi semqoka nakhona ukuthi ukhulume ngebala.
I'm sorry, that is actually a response to the objection by my colleague. It's not a question to him. It's just like that, my lord. That is my response to him, to the state. I'm not so sure whether should I then proceed with my question.
The state is just saying, the witness says it's a summary.
Yes.
So the summary of the facts he wants to convey to the magistrate.
Yes, my lord.
That's what he's objecting to. That should he now mention each and every detail? That this guy walked with a limp and he was lisping when I spoke to him. That's why he says it's a summary.
My lord.
Maybe let's read, what's the section? Otherwise we're going to be here the whole day again. It's section 205. Just read it.
I just want to get my from.
Oh, you want your...
No, yeah, I've already to counsel.
So that we appraise ourselves as to the requirements required for the issuing of a warrant.
In section 205.
205, yeah.
Yes. Well, the section reads as follows. And the heading is: a judge, regional court magistrate or magistrate may take evidence as to alleged offense. Subsection 1. A judge of a high court, a regional court magistrate, or a magistrate may, subject to the provisions of subsection 4 and subsection 15 of the Regulation of Interception of Communications and Provision of Communication-Related Information Act number 2002, upon the request of a Director of Public Prosecutions or a public prosecutor authorized thereto in writing by the Director of Public Prosecutions, require the attendance before him or her or any other judge, regional court magistrate or magistrate for examination by the Director of Public Prosecutions or the public prosecutor authorized thereto in writing by the Director of Public Prosecutions of any person who is likely to give material or relevant information as to any alleged offense, whether or not it is known by whom the offense was committed, provided that if such a person furnishes that information to the satisfaction of the Director of Public Prosecutions or public prosecutor concerned prior to the date on which he or she is required to appear before a judge, regional court magistrate or magistrate, he or she shall be under no further obligation to appear before a judge, regional court magistrate or magistrate. Then subsection 2 is really not relevant. Subsection 3, the examination of any person under subsection 1 may be conducted in private at any place designated by the judge, regional court magistrate or magistrate. And subsection 4, a person required in terms of subsection 1 to appear before a judge, a regional court magistrate or magistrate for examination, and who refuses or fails to give the information contemplated in subsection 1 shall not be sentenced to imprisonment as contemplated in section 189 unless the judge, regional court magistrate or magistrate concerned, as the case may be, is also of the opinion that furnishing of such information is necessary for the administration of justice or the maintenance of law and order. Those are the provisions of section 2.5. So in simple terms, to subpoena a person who might have information regarding the commission of an offense.
Is it please the court, my lord? I'm not so sure whether I need to proceed.
Yeah, proceed.
I stop, my lord. Thank you. Now, Brigadier, we are telling the magistrate that may you kindly assist me to get a cell phone records in terms of section 205, because amongst others there's a suspect. I'm investigating a criminal case. There's a suspect that is involved here, who is described by these witnesses who saw him as a black male with big eyes, having dreadlocks, wearing a khaki or brown jacket or a top and a hat. He was shorter in height than the second suspect. Now my question is, why didn't you tell the magistrate from whom we are requesting this endeavor to call Rakesh, that this suspect that is also that was seen by these people had a dark skin, had a dark complexion? Why don't you bring that to the attention of the magistrate?
Please, Malak, we have already raised an objection, but we have just read out section 2.5. All that the section requires is that the person should have information regarding the commission of an offense. As to this detailed minutiae that my colleague refers to, that is not mentioned in the section.
That is, my lord, That is a very gross misunderstanding of the law. What my colleague has just read now, it has got to do with the person who is being requested to give the information, not what should be contained in the affidavit. This is a directive to the person that what is it that is supposed to do? It's, for instance, in the context of this affidavit, that was directed to Rakesh Ishwaraddin from MTN. Now the investigating officer goes to the magistrate or the presiding officer or the judge and say, can you please order Rakesh to bring this information because we are investigating, amongst others, a case that involves a person who was described by the witnesses who saw him as a black person, a black male, with big eyes, with dreadlocks. He wore a khaki or a brown jacket or a top or and a hat. He was shorter in height than the second suspect. Now my question is, why did he omit to tell the magistrate that the same witnesses who told him that this person was a black male with dreadlocks, wearing khaki, top jacket or hat, he was shorter in height than the second suspect, also had a dark complexion? That's my simple question. Why did he omit to tell the magistrate that?
Yes, my lord. My lord, as I've said, this is a summary. You summarize, that's how Section 205 applications are done. Even when you go for the Section 43 application, you summarize. If you have to include each and every context, I'm not sure how many pages you will write, my lord, because then I'm expected to say, others are saying it's dark, others are saying dark brown, others are contradicting the other ones, others are saying revolver, others, because it's a description of what happened. That's not how you do the application. That's not at least how I know it's done, my lord. This is a summary. It was a summary of what I was bringing to the attention of the magistrate and the reasons thereof. The reasons were the subpoenas of the numbers that were not known to the state when the offense was taking place, and they were subsequently known at the time when I made the application, my lord.
Lana ngizama ukuthi ngiletheke isicelo esifingqiwe ngoba kwenziwa kanjalo akufakwa konke kufakwa nje into efingqiwe ngoba ngifuna ukuthi umagistrate azwisise ukuthi ngicelani ngoba kwenziwa kanjalo uma kwenziwa isection 205 noma isection 43 futhi ke isizathu ke sokuthi sasifuna ukuthi sithole ukuthi ngoba kukhona lezi number lezi esathi ngaphambilini sasingakazitholi lezi number kodwa ngalesi sithathu sesizofaka lesi sicelo sasesinazo yikho ke sasifuna ukuthi sicela ukuthola labo section 205.
And my lord, what perhaps should be noted, because I think maybe we are not on the same page with Advocate Mnisi. This statement was not insofar as accused 3 is concerned. So there's nothing malicious to say one was keeping something away insofar as he is concerned so that the court can make a ruling, for example, in terms of the J50. This was an application for Section 205. In fact, his number does not even appear on this application. It was simply a background because you need to tell the magistrate what are the allegations and the reasons why you want the magistrate to authorize this application, my lord. It's a background, so you summarize. So there was nothing malicious or untoward insofar as accused number 3, because this had nothing to do with him, but it's the background of the case.
Lana futhi kuni engifisa ukuphawula ukuthi lana ke isicelo lesi sasingahambelani nomsolo wesithathu. Kwalokho nje kwakuzama ukuveza ukuthi kuzwakala ukuthi yini indaba sifaka lesi sicelo ngoba sasifuna nje ukuthi kube nendlela ukuthi sendlalele kahle ukuthi kuzwakale kahle ukuthi yini indaba sifaka lesicelo okungaqondene nomsolo wesithathu.
Thank you, Brigadier. You're right. Nothing contained in this document has got to do with accused number 3. All that I'm asking you is, why did you not include the description that you got from the witnesses of the skin complexion of this person that you are requesting this, that you are describing to the magistrate in this affidavit? That's all that I want. Let's got nothing. I don't know how accused number 3 looks like.
Ngifuna ukwazi ukuthi indaba ungayifaka ngencazelo ukuthi umuntu onjani umsolo wesithathu muletha lesi sicelo kumagistrate.
My Lord, I've answered.
Thank you.
It's a summary. I'm not so sure whether, because I think the term explains itself. When you summarize, you don't take the entire context and put it in a summary. That's exactly what it means. It's bigger, you make it smaller. That's what summary says. So what is initially contained here, on the other hand, when you bring it to a summary, you will not have all the facts. Now I'm getting the question from Advocate Mnisi saying I should have explained as if now we are bringing everything from the top to the summary document. That's not how it's done. When you bring an application, you summarize. You simply give the background and summarize the point that you need to create across and the request that you are bringing before the magistrate, my lord.
Saphinda futhi ngiyasho ukuthi lana besizama ukuletha incazelo efingqiwe ngoba besingafane akudingeki ukuthi silethe isicelo esibhalwe konke ngoba kongeyona inhloso le ngoba uthatha okukhulu uyakufinqa kube kuncane iyona into esizama ukuyenza ukuthi kuzwakale nje ukuthi sikhuluma ngani kodwa ngingasho ukuthi sizofaka yonke imininingwane ekhona mayelana nalesi sicelo esisifakayo.
Thank you, Brigadier. As we proceed, I must just remind you that this is an affidavit. It's not a summary, it's not an application. This I'm reading from an affidavit, but nonetheless, let us proceed. Now, on page 333.5, you kick off by saying your affidavit, by saying, it is stated that the suspects fled on foot and the hat which was worn by the shooter was left on the crime scene.
That is correct, my lord. I see that.
Ngicela ngokuthi ke lana abasolwa babaleka bengezinyawo kodwa ke bebaleka isigqoko esasigqokwe omunye wabasolwa sawela phansi. Athi yebo kunjalo.
You further said that the incident took place between, on paragraph 4 of this affidavit, the incident took place between 8:30 and 9 o'clock in the evening, and the deceased was declared dead on arrival at the hospital at 9:15 in the evening. Is that what you're saying?
Uthe wena isahlakalo lesisenze phakathi kwamahora ka-8:30 no-9 wasebusuku nokuthi bafike esibhedlela ngo-9:15 akunjalo?
Yes, my lord. That's what I'm saying. Even the top part of the head being left at the crime scene, it's correct. It's contained in the docket.
Yeah,
The declaration of the deceased when they were declaring him dead at 21:15, it's in the docket. That is correct, my lord. And the estimation, because this 9:30, and it appears in numerous times in my statements that is between 20:30 and 2100 hours, because you have to take into account the call in which the first responders receive and when they arrive at the time. So that's how you calculate it. So yes, that's what I've said, and that's what is contained in the docket, my lord.
Yebo unjalo ngoba bafika nasesibhedlela basho ukuthi ushonile ngo 9:15 bathi ukuthi ushonile. Yebo lamahora abenjalo ngoba kwavela ukuthi cha kwakuyizolo lezikhathi zika 8:30 no-9 wasebusuku.
Now, you go on, you proceed in paragraph number 4. Paragraph number 4, subparagraph 2 thereof says, investigation which resulted in evidence under oath revealed that the victim was murdered in a contractual assassination or hit rather than a robbery or a robbery gone wrong.
La yachaza ukuthi umufi lo wabulawa ngabaqashe ukuthi bombulala nokuthi kwakungekona ukuthi wadubuleka ngesikhathi bezaba ukubamba inkunzi.
Yes, that's what I said, my lord.
Yeah, we're going to ngishilo.
And is this evidence that you had when you applied for this, when you wrote this affidavit in application for in preparation for the 205 application?
Manje lokho awuna ngesikhathi ubhala ke le affidavit yefaka isicelo sika 205.
Indeed, my lord. Yes, I had this application because if you look at the commissioning date, it's dated 2020 December 07. The accused were already arraigned even that time. They already made their first appearance in Boksburg.
yebo kunjalo ngoba uyalibona nosuku olubhaliwe lapha ukuthi abasolwa abasisebeboshiwe sebeyovela enkantolo eBoksburg.
So you basically are saying to the magistrate that no, this was a contractual killing. It was actually not a robbery or a robbery gone wrong. As the office of the DPP has mentioned in their summary of substantial facts, not so?
We're going to rise for the last time on this aspect, and you know, we don't want to interfere with Advocate Mrs. cross-examination, but we submit with the greatest of respect that, you know, we're splitting hairs here. I think this line of cross-examination, and we say this with the greatest of respect, demonstrate a fundamental misconception of Section 205. Section 205, it's aimed at, actually states on there are two jurisdictional aspects regarding Section 205. Firstly, there has to be evidence that an offense has been committed. And secondly, that the person who's been subpoenaed has got that information. So those are the only two jurisdictional aspects that trigger Section 205, namely that an offense has to be committed. The affidavit says that an offense has been committed, and secondly, that the person, the service provider, is in possession of that information. Cell phone records are required to determine if what in or Section 205 records, cell phone records are needed to determine what role any cell phone communication played. This is not a trial before a magistrate. The magistrate is not required to as it were, he's not a trier of fact. All that the magistrate needs to convince himself are those two jurisdictional aspects, that an offense has been committed and the person from whom the information is required is in possession of that information. That can help to resolve the crime in question. Those are the only requirements of the section. What my learned friend is busy with, my lord, will be absolutely of no help as far as Section 205 application is concerned.
Is it please the court, my lord? I'm at no point, not even with a bit of an inch, am I challenging the validity of this Section 205. That is not my aim, and I will never do that. However, it should be borne in mind, my lord, that this Section 205 is based on certain information that the magistrate is being provided with, which information stems from the investigation that is contained in the case docket. Unless my colleague says to me he's not feeling comfortable when I'm raising what is contained in this affidavit, which is accompanying. It's an application. How can I put it? This is an affidavit in support of the application of the Section 205. Unless my colleague is saying that I should not actually question this affidavit because as is, it is as is. But it is not as is, vis-a-vis what this witness testified about in his evidence. Remember, he is the same witness, my lord, who penned this statement, this affidavit under oath, which facts he got from his investigation. So there's therefore nothing wrong with me when I take him through what he presented to the magistrate, which is exclusively based on the nature of his investigation. I'm not challenging the validity of the Section 205.
So what are we about if you're not challenging the validity of the the information which was acquired.
Contradictions. I'm about contradictions.
What type of contradictions?
Contradictions that will enable the court later on to decide whether he's a credible witness or not.
I see.
Yes, my lord.
Yes, let's hear.
Thank you, sir. Now, you are saying in your affidavit that the evidence which you heard under oath revealed that the victim was murdered in a contractual assassination or a hit rather than a robbery which has gone wrong. Now, before you answer, let me complete my questioning. Are you aware that what we have just said here totally contradicts the summary of substantial facts that are contained in the indictment? That you are saying this was a hit when the summary of substantial facts are saying that this is a robbery that went wrong. And in fact, you are saying, sir, it was a hit and not a robbery which has gone wrong. Do you see that?
Well, again, my lord, we want to rise on a different aspect, and we'll find authority to this aspect that the motive for the commission of an offense need not be disclosed by the state in the formulation of the charges. So whatever the motive was for the commission of the offense is irrelevant. If someone has been murdered, what the motive thereof was, my lord, is absolutely irrelevant. The fact of the matter is that murder was committed. We submit, therefore, that what my learned friend is trying to elicit from this witness is it's not in keeping what the law says. It says motive for the commission of an offense is irrelevant.
As it please the court, my lord, again I submit, my lord, that is a dire misunderstanding of the Criminal Law Amendment Act. What is that act now that deals with the minimum sentences? The Criminal Law Amendment Act 105 of 1997, yes. That act is very specific, my lord. And subsequent to that act, so many authorities have come. And if my colleague says that in the indictment you don't need to put a motive, as I'm saying, it's a misunderstanding of the law, my lord, because you need to put in the indictment information that will enable the accused to plead thereto, to enable him to conduct his defense in terms of what the charge sheet says. But nonetheless, my lord, I'm not talking motive here in my cross-examination. I am simply bringing it to the attention of this witness that is he then aware that what he's telling this magistrate, he's saying to the magistrate, look, this was a contractual assassination. He has said he does not know why Kelly would have wanted to kill Senzo because he has not investigated that. But all that he knows is that this was a contractual assassination. But the summary of the substantial facts are saying this is robbery or a robbery which has gone wrong. Now I am saying to you, are you then aware that you're basically negating what the summary of substantial facts contain when you say, no, this was not a robbery or a robbery which has gone wrong, but it was a contractual killing? Is he aware that he basically negates what is contained in the indictment? That's all that I'm asking him. I'm not talking motive. I also don't know why Senzo was killed. He also has said that he does not know why Senzo was killed. Contradictions. Thank you, man.
My lord, I'm not sure. Should I answer? Should I respond? I don't know. My lord, look, if I have to comment, firstly, to say or to make an assertion that this statement A333 contradicts what I've said in my evidence in chief is not correct, because it is in line with what I've said. That's number one.
Sorry, Brigadier. Just to correct, I am not saying it contradicts your evidence in chief. I say it contradicts what is contained in the summary of substantial fact in the indictment, not you.
Oh, I thought it was directed to me.
No,
Okay, all
it
right.
was not directed to you.
All right, okay,
Yes.
then I misunderstood. My
Thank you.
apologies. Secondly, my lord, the issue of the paragraph, the one that deals with the contractual killing rather than the robbery gone wrong. I think it's in. Just want to find it, my lord. But basically, the paragraph that refers to.
Sorry, Brigadier, I realize that it's almost 1 minute past 1. If you want to go through that, I can request an adjournment,
no.
then we go on lunchtime, and then the meantime
no,
we go
let me
through,
just
then you
put-
come and respond to it when you come back.
No, let me just put it. Let
Oh,
me
you
just
want
deal
to
with it.
finish
Yeah,
it?
let me
Okay,
just
that's
deal
fine.
with it. It will be
Yes.
short, my lord. What I'm saying, my lord, is that the paragraph that refers to the incident being a hit rather than a robbery gone wrong. I also dealt with it, my lord, when I applied for the warrant of arrest of the accused. On the application for the J50 it is dated 23 August 2020. This is before the warrants were authorized. So it is not a new thing. I've dealt with it right from the beginning, going upwards. I've never kept that part away, and that is because the investigation revealed such evidence. So it is not for me, my lord, to take left when evidence is pointing me to right. That's the second part. And thirdly, and I've said this, my lord, I cannot speak on behalf of the NPA. I think the powers there are clearly separated, and I'm not the one who can answer to that. I can only account to what was contained in the docket and what I presented to the magistrate. Now, if I had went to this magistrate in Johannesburg and presented facts which are different to what is contained in the docket, that would have been a crime, my lord. I could not say when evidence sitting before me indicates that this was a contractual killing, then I say something else. This was based on what is contained on the docket, and I presented these facts as they are. That's the truth, my lord.
Thank you, madam. May I request for an adjournment for lunchtime? Thank you, madam.
Continues with cross-examination. We just want to hand up this affidavit that is being used currently. The defense indicated that, Advocate Nisi indicated that would like to hand it up. The last exhibit was the W series, but we just want to keep it together with the previous affidavit of Brigadier Gininda that was handed up in the trial within a trial. Just looking for the reference to that affidavit. I think it would be Linda. Anyway, we will come back to it just now. Just before we adjourn, my lord, we just wanted to make quick 2 points. And the first one was that my colleague referred to the issue of intention, the minimum sentence legislation, and said, and said the state was misconstruing the issue of motive. We submit that motive and intention should be distinguished. What the minimum sentence legislation is referring to, it's intention, not motive. And we mentioned, my lord, that motive as well as the commission of the crime should not be conflated. And just briefly, Stayman's Criminal Law, 7th edition, says at page 169, intention must not be confused with motive for committing the crime. In determining whether acts acted with intention, the motive behind the act is immaterial. And just secondly, my lord, these issues that we're debating are the issues which at the end of the case the court will have to make a finding on. So we are in in our submission, my lord, that we're dealing with, or we are arguing the issues that should be argued at the end of the trial and not at this point. Thank you. The last exhibit of Brigadier Gininda was exhibit Z. Maybe we can make this exhibit ZZ1,
Okay.
just to keep them together. Thank you, madam.
Any response about section 51? 1 and 2. Yes.
Thank you, my lord. Thank you, Brigadier. I am just trying to find out if I'm done with ZZ1, the statement that we were busy with before we went on the lunch break. It's just a general question. It came many a time in your evidence in chief. You kept on saying that Kelly, there are numbers of a cell phone that Kelly did not disclose to the police, not so?
That is correct, my lord.
Kukhona inamba ezingavezwanga emaphoyiseni athi yebo.
It sounds to me like if that is really a correct statement is put the way in which you are putting it. In other words, Kelly willfully, and I said I'm not here to plead her case, but then Kelly willfully held the information from the police.
Well, indlela engala ngayo ngathi uthi uKelly wafihla ngenhloso ulwazi oluthize emaphoyiseni.
My lord, I'm not sure how should I answer that because the context in which these numbers were discovered through the expert is that they were active and they were being used on that day. So I'm not sure anything else. I'll be speculating. What I know is that they were active and they were not disclosed to the investigation team at that time. They only gave 2 numbers. Those are the facts in the docket, my lord.
Engikwazi ukuthi nje lezi numbers zange zivezwe emaphoyiseni kodwa zo inamba ezisebenzayo azizange nje zivezwe emaphoyiseni.
Yes, because I would then have asked you if you've got any form of information or knowledge or even evidence to suggest that they asked her if she's got other further numbers and then she decided to say, no, I don't have numbers except, cell phones, except for the one that I gave you.
Angazi noma unalo ulwazi lokuthi bambuza yena wathi unazo yini ezinye inamba yena ke ungaziveza kodwa waveza nje kuphela athi nazo enginazo.
My lord, I was not there on the first investigation team that was dealing with this matter. All I know is that these numbers were not disclosed, but the details of the interaction of the police officers with Ms. Kumalo, I think that will be left for them, my lord.
Ngangingekho ngesikhathi ke ebuzwa kodwa ukuthi bayakhuluma bathini naye ukuthi mniningwane yakho niyathola.
Thank you, Brigadier. That was just by way of intro, because I got a little bit concerned when you kept on saying that she did not disclose, as if they requested her all her numbers and then she decided to disclose some and not disclose others. But thanks, as you say, you don't know what actually transpired today. Thank you, Brigadier.
Ukhuluma ukuthi bekuzwakala sengathi uthakavizanga lo vele kwabasengathi uthi wayenenhloso yokuzifihla lezi namba.
My Lord, I'm saying they were not to disclose. I'm not bringing myself to the conversation with the police. If you look at the docket, there's nowhere where they said these numbers were disclosed. They were not known to the police. That's what I'm saying.
Okusho ukuthi inamba zivezwanga nokuthi ke azizange zidluliselwe emaphoyiseni.
The only numbers that were disclosed insofar as the docket is concerned are the two cell phone numbers, the runaway phone and the one that was downloaded. That's what is contained in the docket.
Ngikwazi ukuthi izimbili nje inamba ezalethwa kuthiwa ilenye nale yade download.
Thank you, Brigadier. Now, there's yet another statement, affidavit, which you made. I am just not so sure whether this one was made in application for a certain information to be made available to the investigating team, but it seems to me like it is a standalone affidavit, and it is labeled as page 100 as A198, and it has got 6 pages. It was deposed to. There's a date stamp there. It has got 6 pages. There's a date stamp there. It has actually got 2, the commissioning part, which is handwritten, has got a date of the 3rd of October 2020, and it was done by Detective Sergeant Bibi Mohola. But then there's also a date stamp there, which is dated the 23rd of October 2020. As I read it here, it's from the Senior Public Prosecutor, Boxback, something like that. I'm not so sure whether you've got it. But the one, may I just show you this one that I have?
No, it's not necessary, my Lord. I've got it. That is the.
Oh, you've got it.
I've got it. That is the affidavit in relation to the application of the warrant of arrest for all the accused before court.
Khona ke le affidavit oyibhala angazi noma i-affidavit ingathi i-affidavit eyizimele, and lena i-A198 inamakhasi ayisithupha. Sengathi ke lana ya commissioner ngomhla 3 October 2020, futhi khona ke futhi nenye ke idate lapho mhla 23 October 2020 ngathi yayi idluliswe ku-Senior Public Prosecutor ngicabanga ukuthi wase Boxback. Siyaphendula ukuthi no yayimayelana nokukhishwa kwama-warrant of arrest, kusho ukuthi incwadi esigunyaza ukuboshwa kwabasolwa.
Okay, thank you. Mr. Ramusipil is bringing to my attention that there is an affidavit dated 23 October 2020 as Exhibit ZZ that has already been admitted, my lord. I'm not so sure whether it's this one, because as I'm saying this one, the handwritten date says the 3rd of October 2020, but the stamp which was fixed by the Senior Public Prosecutor Boxback says 23/10/2020. So I'm not so sure which one was admitted. It's the same one. Okay, thank you. That's Exhibit ZZ. Thank you. That's Exhibit ZZ. Thank you, my lord. I'm told it's already on record as Exhibit ZZ. Thank you, my lord. Now, I would want us to go to paragraph 3. I think now that it was already, I can't remember the circumstances under which
It was set up by Mr.
Ngomezulu.
Zulu when he was arguing that the warrants were unlawfully obtained. Am I correct, sir?
I beg your pardon, my
I
lord.
say Mr. Ngomezulu used to utilize it when he was arguing that the warrants
Correct, my lord.
was incorrect.
That is
issued,
correct, my lord.
unlawfully issued, etc., etc.
Correct, my lord.
As it please the court, my lord, I would assume that, very cautiously though, that it has already been authenticated, my lord.
Yes.
Thank you, my lord.
That's why I'm able to quote what it was upended for.
As it please the court, my lord. Paragraph 3.3 of the affidavit. The anti-penultimate sentence of his affidavit, that is the last but one, that starts with, upon the accused arrest, 3.3 in both letters deals with the circumstances of accused number 3, Mr. Mtobisi Prince Mnuwe. Now,
Correct, my lord.
yes, the anti-penultimate sentence there states, that's last but one, says, upon the accused arrest for a 2015 convicted murder, a cell phone was seized in his possession. Now, the cell phone downloading of his cell phone were done. Now we go to page 4 of the affidavit. It reads thus. The photos found on his cell phone memory showed him wearing the same clothes that were identified by witnesses on the day of the incident, as the accused was in possession of the revolver upon entering the house. He carried the revolver upon entering the house. Are you with me?
I'm listening, my lord.
Thank you, Mr. Ngo.
Kukhona ke umusho lapha owandulela umusho wasekugcineni. Uthi ke lo musho ke ekuboshweni ke kukaMsolwa ngo2015 ukuboshweni kaMsolwa eboshelwa ukubulala ngo2015 iselfoni ke yathathwa kuyena le cellphone ke kusho ukuthi kwakhishwa okungaphakathi kwa downloadwa and futhi izithombe ezatholakala kuleyo cellphone zamkhombisa yena egqoke lezi impahla ezakhonjwa aba ofakazi ngaleli langa lesehlakalo kuthiwa uyena lo Msolwa owayephethe ivolovolo ngena endlini.
Thank you, Brigadier. Now, wearing the same clothing that were identified by witnesses on the day of the incident. Let us just pause there. That's the extract that I would want us to concentrate on. Wearing the same clothing that were identified by witnesses on the day of the incident. Thank you. I want us to
Asiyabuleli
concentrate.
phuzu ke lithi wayegqoke impahla ekuyilezi impahla ezazigqokwe ezakhonjwa njengeimpahla ezazi ofakazi kuthiwa kwakuyimpahla ezazigqokiwe ngelanga lesehlakalo ezigqokwe uMsolwa owayephethe isibhamu.
Thank you. Now, may you kindly explain to this court when you tell the magistrate that these clothing were identified by witnesses as the clothing that he wore on that day, when did this identification take place of this clothing?
Manje ke lezi impahla leyo kwakuphuma phike kwavela nini ukuthi ayigqoke lezi impahla njoba washo ku utshela imanje.
So, my lord, I think perhaps we must read the sentence in terms of what he's saying, and then you'll understand, because there's no confusion insofar as I understand it. I'm saying, this is now if you go to page 4, the photos found on his cell phone memory showed him wearing the same clothing that were identified by witnesses on the day of the incident.
Yes.
Witnesses identified that the guy, the suspect with a firearm, was wearing a brown khaki jacket.
Yes.
I've referred to what to those pictures. So if you read the meaning of it, I think perhaps we're reading it in a different context with Advocate Mnisi. There was a description given, a downloading is done, he is seen, and we dealt with those photos where he's wearing a khaki top. That's it. So it's not saying there was a physical identification of the clothing. If you read that sentence collectively, you'll understand the meaning, my lord.
Yebo, la kufanele uyifunde iyonke ukuthi uze ukuthi kuthiwa ngoba vele bese sichazile ngakhombisa mfuna sisithombeni ukuthi nanga yaloko akwakusho lapha kwavela phela eshufonini lesi sithombe lesi sikhombisayo ukuthi wayegqoke into enje kwakungekona ukuthi kwahamba wayokhonjwa othiwa nanga ugqokile cha yiloko kwavela lapha esithombeni ukuthi wayegqoke lezi impahla lezi sichazwa ebathu mabekhuluma ngazo abasolo zabonakala nasesithombeni.
Brigadier, let me help you. This sentence simply says, upon accused number 3's phone being downloaded, they found certain photos. Those photos were then taken to the witnesses to go and identify the clothes.
That is not what the sentence is saying. The brigadiers explained that it merely says, they describe the clothing in their sentence. I don't know whether counsel wants to take issue with him about what he wrote in his own statement.
I'm not so sure whether I need to respond them because I am reading what is annotated here, what is written here. There is no word description here. It says unless the brigadier is saying now, no, it could have been the fact that I was let down by the usage of the terms or English. I actually intended to say the clothing that appeared on the photos that were downloaded on the cell phone memory fit the description. Is that what you intended to say, Brigadier?
My lord, in English you get synonyms. One way it may be interpreted in a different way. I've explained what I meant. There was no identification of clothing and the docket speak itself on the day of the incident. What was given is the type of clothing the perpetrators were wearing. Now I've said if you take that to the downloadings, and I've testified about it, that there were similarities in terms of the jacket, the top, the brownish khaki jacket worn by accused 3. That's what this sentence means. So if Advocate Mnisi wants to interpret the word identification as being a physical identification, that's why I'm saying that's where we're not finding each other, because that's not what I've meant here. I contrasted this. I've drafted this affidavit, and that's not the meaning that I had in mind. What I meant is there was a description, perhaps to use this term, given by the accused as to how the first intruder was, what he was wearing, and the type of the clothing that he had. Fast tracking to the downloading of the cell phone, a similar clothing is found fitting that description, if I must use the term, so that we agree. Not necessarily that there was a physical identification of clothing, my lord.
Manje ke ngifuna ukubeka lana ukuthi ke kukhona amazwi amagama athi umesetshenziswa kube amagama asho into eyodwa. Kodwa ke amagama ebengizama ukwasebenzisa la befuna uzama ukuchaza ukuthi yebo kwaba nencazelo yabantu abachazayo ukuthi umuntu wayegqokeni. Uma sesiyake ezithombeni sithole izithombe ezina lezinto lezi achazwe ukuthi wayezigqokile. Angasho phela ukuthi bengafuna ukuchaza ukuthi kwaba khona ukuthi umuntu amiswe lapha kuthiwa khomba ukuthi yini la egqokile ukuthi nange uye lo ogqoke le yanto kodwa ke ngisho ukuthi ke sasiphela sasiqhathanisa lokho kwakutholakala ezithombeni nalokho okuchazwe yilabantu ababesifakazela ababofakazi.
Thank you, Brigadier. I won't take issue with the usage of terms like identification and description. At least now you are explaining it, that you actually meant to say description. But when I read it, I said identify. Identify means you just go and have a comba thing, like to go and point it out. Do you understand? But thank you for the